Here we go.
This Thursday.
I was already saying,
When he got up, I said, "That's not down."
it's just like,
Okay. No, I thought I had lost it. Okay. Your name, sir?
Robert Downer.
All right. Are you having problems hearing at all?
My hearing's a little bit, but I'm fine.
No, we have equipment that.
No, that's fine. No, I'm
Are
fine.
you sure?
Yeah.
Okay.
It's just when I'm in a big room, it's just,
Gotcha. Well, just so that you know, we do have headphones that will direct all of the sound right.
that's fine.
You're okay?
I am.
Okay.
Thank you.
All right. Not a problem. All right.
Your Honor,
Go ahead.
Ask me. But
What?
I'm a lot older than he.
That's because I care about Mr. You want equipment, Mike?
No, I'm
Okay, thank you. All right. Just trying to be fair. Raymond, you're good?
What was that,
Oh, boy.
This is how the day starts. All right. All right. So in Mr. Downer's case, I have a plea form, but before I get to that, there was a motion to suppress. You're withdrawing your motion to suppress.
yes.
And then I have before me a plea form that indicates that the defendant will be pleading to open intoxicants in a motor vehicle, a 90-day offense. Upon a successful plea to that charge, count one would be dismissed. That is the court's full understanding of the.
That's correct, Your Honor.
Is that correct?
Yes, Your Honor.
All right. May I have him sworn?
Solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. God,
Yes, sir.
state your name, please.
Robert Downer, DOWNER.
Sir, it is this court's understanding that you are going to be pleading to the charge of open intoxicants. That is a misdemeanor punishment by up to 90 incarceration, a $100 fine plus court costs. You understand that?
Yes.
All right. Understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
I didn't hear.
Special rights form.
Did you sign an advice? Okay.
Yes.
Do you have any questions regarding any of those rights?
No, sir.
All right. Please look at paragraph 5. You'll see a copy on the podium there. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of rights. Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you are indeed guilty?
Yes.
On the date of December 9th, 2025, at the location of Carpenter and Packard Road in Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
Yes.
And contained in that vehicle, was there alcohol?
Yes.
All right. And do you recall what the alcohol was in the vehicle?
Yeah, it was an empty beer can.
A beer can? And the seal was broken on that beer can?
Yes.
All right. And there was some liquid of some type in that beer can, is that correct?
Yes.
All right. Sir, I do have to advise you that, well, let me do it this way. Sir, I'll just give you those rights. Sir, I do have to apprise you that if between the time of sentencing and the time of my acceptance of your plea, if you commit misconduct under the Michigan court rules, as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that, sir? Is counsel aware of any other promises, threats, or other inducements which have led to this point?
None.
And have I complied with the court?
Yes, Your Honor.
Yes, Your Honor.
All right. Court will accept the defendant's plea to count 2.
Your Honor, at the appropriate time, may I address the court?
Yes. And count 1 is dismissed. Yes, go ahead, Mr. Minton.
Mr. Downer, 60 years old, runs a business, never been in trouble. I'm requesting immediate sentencing. I informed him it'll be 2 points on his driving record, and it would be fines and costs attached to this.
We hold just one. What is today? 24. I should know that. It's the middle of Prime Day. All right. My concern, and I don't know, and maybe the people can speak to this, is that the fact, I understand the plea, but the factual circumstance of this case is that there was a 3-vehicle crash of some type. That's what my notes reflect.
Let me double check that. Is 3, I know it was a crash.
There's
3 vehicle.
Your Honor, he was coming out of the parking lot of all the businesses on Carpenter Road. It was wintertime, had some ice, slid across one car, and then he ended up getting hit by a second car. No injuries, except my client, who spent how many days in the hospital?
15.
15 days in the hospital. No other person was injured.
Okay, I understand all of that. I guess what I'm not getting at is whether or not I would give their claim anything. Are there individuals that may, because of the conduct of the defendant, have a claim to restitution?
There may be. The problem, part of the reason that went into this plea and the reason it was offered is because those individuals were never named or identified in the report. So we've had no way to contact them or see what their thoughts are moving forward.
Okay, so the individuals involved in the crash were not identified, don't have their names or anything, so.
Correct. Neither their names nor their vehicles were listed in the report or identified. It just says, according to witnesses.
Got it.
And to my knowledge, there's been no civil litigation of any kind.
Okay. Then unless there's an objection, I'll proceed with sentencing. Is there anything either you or your client want to say before I do impose sentence?
Other than I've represented before, Your Honor, I've got to know this gentleman, good guy.
So you were taken into custody at some point, right?
No, I was taken to the hospital in the ambulance.
Okay. And were you released then from the hospital, or did they take you to jail?
No, I was released from the hospital 15 days later.
For a considerable amount of time there.
Got it. Okay. Sir, is there anything you want to tell me before I impose sentence?
Oh, I just hope this is all done and over with. And it's been a bad 7 months as it was, just trying to heal. I mean, I broke everything on my entire body, and it was the worst day of my life that happened.
I'll order fines and costs of $350. I'll suspend 90 days in jail. I'll leave any claim for restitution open for the next 90 days. But we probably
Pay that today.
When can you pay that? Today?
Today.
Thank you. Pay that today out at the counter and you're all set. Thank you, sir.
Yeah, just go down there. Got to wait a little bit for the file to get down.
Take a few minutes.
Yeah.
Okay. Thank you. I'll call you.
This is so. And this belongs to whom? Who has one of? I got it. Never mind. It's in big red letters there. She's here, right? Okay. Court does call the case of the People versus Aaron Williams.
Your Honor, Raymond Cook for the people.
Your Honor, Michael Goodson, on behalf of Mr. Williams. Mr. Williams.
All right, and this is an evidentiary hearing regarding the motion to suppress.
That's correct, Your Honor.
All right. Okay, are we ready to proceed on that?
Yes. Just as a preliminary matter, I believe at the last, excuse me, the last hearing, the defense asked that the people secure, I believe Angelia Hayes is the witness's name, is the girlfriend of the defendant that the troopers spoke to after the arrest. We were unable to get that witness's appearance today, so I have the trooper, but not that witness.
Mr. Benton, you're aware of that?
I was informed of that this morning.
Okay. Okay. Well, understood. I guess, do you want to proceed with them not having that witness, or? Well, let me ask this. That witness, at least as I understand from the motion, is part of all of this because of her relationship to the defendant.
Yes, and because of statements she made to the trooper after the defendant was arrested.
Right, but she's there. She's there because there's some relationship with the defendant.
Yes,
It's not like she was some person just standing on the side of the road and
correct.
was there.
It was a dating.
Okay,
I think we go forward today.
okay, all right. Because I was going to say that it would seem to me that you might have well, depending on how the relationship turned out, you might have a better shot than David. But okay, if we can go ahead, we'll go ahead.
Called Trooper Lewandowski.
All right. Trooper, if you come forward and be sworn.
You say C, raise your right hand. To affirm the testimony about giving be the truth, the oath. That's what you said.
Yes.
Facebook, your first last name.
First name is Hannah, H-A-N-N-A-H. Last name Lewandowski, L-E-W-A-N-E-O-W.
O-W-S-K-I. Okay, got it. Okay. Go ahead. You may inquire.
Thank you. Good morning, Trooper. How are you doing? Doing just fine. Thank you for asking. Trooper, how are you employed?
I am a trooper with Michigan State Police under the Brighton Post.
How long have you been working for Michigan State Police?
A couple, 2 years.
Any previous law enforcement experience? On or about October 30th, so the night of October 30th, going into the early hours of October 31st of 2025, were you on shift that night? At any point in time, were you on or at or near I-94 near State Street? And at around 11 o'clock that night, did you ever have contact with some vehicles on the side of the road? Can you describe to the court what that how that contact began?
So I was traveling eastbound on I-94 State Street when I observed a vehicle, a black Ford Flex, parked on the right side of the shoulder, with a second vehicle, black Mazda, facing the opposite way of traffic. I activated my emergency lights and made contact with the occupants of the Ford Flex.
You said that these were on the shoulder. Were they entirely on the shoulder, or were they on the road at all?
They were on the shoulder. Okay.
Both vehicles were? And the Mazda you said was facing the opposite way. So would that be westbound?
Correct.
Why did you pull over, or why did you make contact with these vehicles?
It seemed like I saw occupants outside of the vehicle. So a car assist I do on a daily basis. So I need just to make sure that no one needed assistance. Me.
Who did you first make contact when you arrived?
I made contact with 2 females. They advised that they were on their way home and they got a flat tire. Upon making contact with those 2 individuals, I learned that both females were either suspended or revoked.
At any point, do you have contact with an individual by the name of Aaron Williams that night? Do you see that individual in the courtroom today?
I do.
Can you please point to them and identify them by an article of clothing they're wearing? The record may reflect this witness has identified the defendant.
Without objection, the record will reflect.
When did you first have contact with the defendant?
I believe it was the initial contact. I observed him walking around the vehicle trying to fix tires.
When you say the vehicle, is that the Flex or the Mazda? At that time, was there anything about the defendant's demeanor or speech that made you suspicious that he may be under the influence of any sort of intoxicating substance?
No.
How much interaction did you have with him at that time? None? What did you do after you made contact with these two females?
After I made contact with two females, I returned back to my patrol car, ran them in lane. I then got out of my vehicle, addressed the situation with them. I made contact with the Mazda, which was occupied by two, was Mr. Williams and Mrs. Angelina Perry, who identified as Mr. Williams' girlfriend.
Did the defendant indicate how the Mazda came to be at that location?
He said he was coming from his home in Ann Arbor and was there to assist his girlfriend's father.
Did he say who was driving that vehicle? Who was driving, or was driving that vehicle? You said he was coming from Ann Arbor. Did he say when he left to come to that scene?
Said he was just got done watching a football game and was requested by his girlfriend to come to the venue.
Do you remember which football game he said he was watching?
Who? Dolphins versus Ravens?
So
I don't think I like either one of those teams, but whatever.
At what point did you become suspicious that the defendant may be under the influence of either alcohol or some other intoxicating substance?
when I returned back to my vehicle, I requested him to turn the vehicle facing the proper traffic. I returned back to my vehicle just in case I needed to block a lane off for him to do so. When I was in my vehicle, he got out and I observed him unable to maintain his balance with walking his roadway, which made me concerned. I got out, addressed the situation.
When you say walking in the roadway, how far into the roadway did you observe the defendant?
Over the lot line and travel.
And was this before or after he turned the vehicle around?
After.
You said you addressed the situation. What did you do to address the situation?
I got out of my patrol vehicle. I said, sir, walking the roadway. He then came towards me. I was talking to him. And that's when I started smelling odor of intoxicants coming from him.
How close were you to the defendant when you first noticed that odor of intoxicants?
Arms 5 feet away.
At that point, was there anything else about the defendant other than the odor and the walking that gave you reason to believe he may be intoxicated?
I was asking him simple questions and he was unable to give me, he was look at me in the eyes or answer questions I asked him. So based on those observations and indicators, it's when I started to get my reasonable suspicion on the.
What did you do after you became suspicious the defendant was intoxicated?
I asked him to perform a series of sobriety tests.
Which sobriety test did you have the defendant perform?
3, I had him do the first, the horizontal gaze and stagnus. Second, the walking turn. Third, one legs.
And I'm going to assume the court has familiar with those. I'm going to skip over a lot of the details of those for the purpose of
25 years. Yeah, kind of. All right.
what indicators, if any, did you of intoxication observe during the horizontal gaze and the stagnus test?
Last smooth pursuit, distinct and the same stagnus on a maximum deviation, and onset and stagnus prior to 45. I observed all clues in the defendant and had to remind him multiple times to follow my stimulus.
Why did you have to remind him multiple times? Was he able to follow the stimulus? What was he doing that was unable to follow the stimulus?
Just kept on staring at me, not following my directions or maps.
Okay. So he was looking at you, not the stimulus. What was the next test that you had the defendant perform?
The walk and turn.
And what indicators of intoxication, if any, did you observe during the walk and turn test?
Stepped off line and missed heel to toe several times.
Do you know how many times the defendant missed a heel to toe step? Okay. And what was the third test that you had the defendant perform?
One leg stand.
And what indicators of intoxication, if any, did you observe during that test?
I observed him set his foot down several times and sway while things.
What did you do after the conclusion of those tests?
After completing his interview and sobriety test, I requested him to submit to a criminal PBT. And which he refused.
At that point, what happened?
After he refused submitting the PBT is when I placed him under arrest for operating while intoxicated based on my SOSTs.
Following the defendant's arrest, did you go back to his vehicle?
Correct.
Were you able to see inside the vehicle at any point?
Yes.
When you looked inside the vehicle, did you observe any containers of alcohol?
I did not know.
What about in the surrounding area? At that point, who all was in the defendant's vehicle?
At that point, everyone was, the two females were in the vehicle in the back seat, and his girlfriend was also in the vehicle.
Did you speak with the defendant's girlfriend about the defendant's intoxication?
No, to object to anything, his girlfriend had to say as hearsay. This is a witness, that they had an opportunity to bring to court today, and she's not in court.
Your Honor, I have two responses to that. One being that this would go toward, this entire hearing is about the officer's belief and reasonable suspicion. I believe this goes towards her belief in her investigation. And second, I think that this is a preliminary question for the purpose of admissibility of evidence. I'm not sure that the rules of evidence and the rule against hearsay would even apply at this point.
It's clear hearsay, she,
Well, if it's being offered for the truth of the matter asserted as opposed to this trooper's state of mind and then her subsequent action.
they address that. Would you mind if I sit down or?
No, that's fine if you say.
Obviously, if the truth of the matter is certain, why else would the trooper ask that question?
Well, I don't mean to make anyone's argument, but I can surmise it this way. The trooper observed certain things regarding this defendant. She then places him under arrest. She's continuing her investigation, and she's talking to those witnesses in terms of how she's going to then proceed. So
My understanding that placed under arrest after the girlfriend was found.
it's not right.
That's not the testimony that I.
Go ahead, yes.
I placed him under arrest for operating while intoxicated. I placed him in my patrol vehicle. I then recontacted the.
Yeah, so. Because at that point, and again, to address your issue, and I know the trooper certainly can speak for herself, but I have 3 individuals now. I have 2 vehicles, but I have 2 of those individuals don't have a valid license and can't operate. So she's got to continue doing something.
I don't disagree with that, but I do believe there's a lot of things. Certain fact, that's not an evidence. She's not here, and we addressed that specifically the last time we were here. They have this witness here, so we wouldn't have to deal with her. And I do believe,
But it's not being offered for the truth of the matter, sir. If the trooper, I might agree with you if the trooper had not placed him under arrest at the time, goes, speaks with her, uses that information then to decide, I'm going to now arrest. I might agree with you, but he's already arrested. So I'm going to overrule the objection. I'll allow it for that purpose.
And do you need me to ask the question again?
Okay.
Did the girlfriend make any statement about the defendant's intoxication that night?
She did.
What was that statement?
She advised that they were both at his residence and that he was alcohol prior to driving.
After that conversation, what did you do next?
I informed her that he was arrested for operating while intoxicated. And she advised, which I knew prior, that she did not possess a valid driver's license as well. So I then had to go on the steps to make sure that they were driven home by a valid driver.
Going back to an earlier statement or earlier question, you previously testified that the defendant indicated watching, I believe it was Ravens-Dolphins game that night. Do you happen to know what time that game started? I just asked the court to take judicial notice that that was a Thursday night football game started.
I'd like to object the judicial notice on what time the football game started or anything else about two teams I don't give a hoot about.
Well, is that last part of your objection? I mean, well, I'm a Steeler fan, so I don't like the Ravens, but I think, I mean, I could take judicial note. What would be the relevance of me knowing the time?
It would go to the timing as for when the defendant was driving, because I anticipate there may be an argument that the trooper did not have knowledge exactly when he was driving. And so with the understanding he was watching a football game, knowing when that football game was on gives the court a time frame as to when the defendant would have left the house and began driving.
Okay. I'll overrule the objection. I'll allow it.
I believe those, I put in my motion, let me put up here because I don't have the time. I think it was 8:15 p.m. is when that game began that night.
Got it. And what time was there stop?
11 o'clock, I believe.
11 o'clock. Got it. Okay.
I can have just 1 second to look at my notes, please, Your Honor.
May I further objection
Certainly.
that because the game started at that time, there's no proof that's what Mike Simon watching the game.
I'm happy to address that objection in the argument.
I mean, like it was delayed and he's watching it later, or
I don't know what time he sat down to watch it. Why does the game start? Your time starts at 8:15, doesn't mean kick off. I'm not sure what the role of all this is either.
I think it's just to pinpoint there's information that the trooper received that he was watching the Dolphin Ravens game. The encounter on the side of the road is around 11 o'clock. So what the people are getting in and want the court to take judicial notice of is the start time of the game. Now, there might be argument as to what the court does with that, but what weight I should give it, because if it was delayed streaming, I mean, I get your point, but I would still allow it. Certainly, you can argue the weight that I should give it.
My basic argument is what's the relevance.
I think it can be relevant, at least as a time frame, so I'm going to allow it.
I think at this point I'd pass the witness.
All right. Cross-examination.
Good morning. What day of the week was this? Thursday?
Yeah.
And what was the traffic like at 11 p.m.?
Traffic.
Light traffic. And read through the report, and I got the impression as you were pulling up, you saw Mr. Williams kind of walking around someone in the roadway.
Not at that point, no,
Okay.
that was. You want me to fully answer? That was after walking the roadways, after I watched him flip around.
How did you know he was the driver of that car?
Of the monolith.
Yeah. And so you were close enough to ask him that question, correct? And you were how far away from him when you asked him to move the car? A foot, 2 feet? Close, right?
Oh,
And he's in a car, and as you know from your experience, is if somebody's been drinking in a vehicle, it holds the smell, correct? And you were close enough to talk to him, to instruct him, and he was close enough to you to respond, correct? And I noticed in your talk prior prosecutor questions, you never indicated that he slurred his speech, correct? You never indicated that he didn't understand your directions, correct?
sure.
When he's sitting in the car, you ask him to move the car.
It's changed in the direction.
He understood your directions, right? And there was another person in the car with him, correct? And you obviously should have been able to smell anything on him at that point, right? Because you're right on top of him. Okay, so you didn't smell anything on him?
Okay.
Did you have any suspicion that he might have been drinking?
Yeah.
Yeah, none at all?
Point.
Okay, that's because he didn't slur his speech. He understood everything you asked him to do. He responded properly, correct? And I noticed in your report that there wasn't any problem indicated. He had to back the car up and then pivot around, correct? He had to turn around. He had to turn the car to face it eastbound.
It's a proper way of traveling.
And I didn't read anything in your report that there was any difficulty him doing that.
He had to maneuver to.
So you would agree with me, he had no difficulty doing that. And it's somewhat of a difficult move, backing a car up on the shoulder of the expressway and then turning it onto the expressway. Now, you did not move your scout car, your vehicle to block a lane or anything like that. I didn't read that in there either.
Maybe I included, I can't remember if I did or not. I would turn back my vehicle if I.
Okay, but you can't remember whether you blocked the lane or not. If you can't remember, you can't remember. And again, I already asked you a question, but there's nothing in his driving, nothing in his ability to move that vehicle off the shoulder road, back up, then make a complete turnaround to face eastbound. Correct? Did he pull his vehicle back up onto the shoulder?
Tires are on the fall line.
He was off the roadway, correct?
Correct.
And you didn't notice any problem with any of this at all to indicate that he was intoxicated?
Correct.
Right. I'm somewhat familiar with the shoulders of the roads of 94, and they're sloped, aren't they? That slope down, so when the rain falls, it doesn't make puddles, it kind of drains off the side. Okay. So what is the shoulder of the road made of? Gravel?
No, it's concrete.
Concrete. This was at night, and he was on concrete, and he wasn't able. Now, you saw he wears glasses, right? What did you do about that? Did you have him take glasses off or leave them on?
He put them on, but I can't recall.
Okay. And you know the glasses would affect the horizontal gaze nystagmus test, correct? You don't remember that? Okay. And he wasn't able to hold his leg up for any significant amount of time and have to put it down, correct? Did he ever stumble, fall against a vehicle? Did he fall down on the ground doing these tests? Where did you have him do the test? Between the two vehicles on the shoulder of the road?
I have in front of my patrol vehicle.
For your patrol vehicle?
Correct.
And that's with the overhead lights going, correct? And your spotlight is on, no doubt? The bright lights are certainly, your lights are certainly on, correct? So between your vehicle and the flex vehicle, you had them do these tests. The court, can you give me 1 minute?
Yes.
And I noticed in your testimony again, you did not indicate that he was slurring his speech or anything like that, right?
Correct.
That has been answered.
And
I'll let it go.
go ahead. And on doing these tests, he understood you gave him directions, correct?
Correct.
And he understood your directions.
I'd say no,
He didn't understand them.
remind them and ask him numerous times.
Okay. How to do these tests. Would you agree with me? These are not normal tests that people practice every day.
Spills.
Standing on one leg. When you did the walk and turn, you have the people stand in an odd position before they start. Would you agree with me on that? Kind of 1 foot in front of another and have to wait till they're told to move forward.
Correct.
All right. Thank you.
He redirect. I do have a question. So you had indicated they're at I-94 in state, so exit 177. There's a lot of stuff I don't know. I don't know why I know that. Anyway, going eastbound, were the vehicles at the Cloverleaf, before the Cloverleaf, after?
We're like just past Hanover facility. We're at the Cloverleaf.
So you're, okay, I got you. So,
We are in between Hanover Lane and State Street.
so between 175 and state, you're going eastbound.
East.
Got it. Okay. Okay. Was it talked about or was it determined how the Mazda came to face westbound? Was that even? Okay. It was just, that's where it was when you saw it.
Correct.
Okay. All right. Good.
I have no redirect, Your Honor.
Anything else based upon the court's questions, Mr. Benson?
Following up on Judge talked about, it's pretty unusual to see a car up in the shoulder of the road facing the opposite direction.
Yes.
And it would be especially unusual to have this happen around 11 p.m. And you had no suspicion at all that the driver of that Mazda might have been drinking.
Sorry.
You had no suspicion at all that the driver of that, it was a black Mazda, if I remember correctly, you had no suspicion at all that he might have been drinking?
At what point?
At any point up to the moment you encountered him on that 11 p.m. I think it was on the 30th of October.
Sorry. What are you asking? Are you asking if yes, I observed signs of intoxication from the truck.
Okay.
Are you asking at what duration during my encounter with them?
No, you answered my question.
Oh.
No other questions?
All right, thank you.
No, regret. Thank you.
All right, you may step down. Thank you. Any additional witnesses for the,
No, Your Honor. No, we have another issue now. We have to file Frank's motion on the search warrant.
okay,
Unless the court wants to have us deal with that now. I indicated in my motion, what that's. I didn't go into details.
right, but I don't,
The court wants to be on Frank's motion on that.
well, if it's necessary, I mean, what would be the basis of the Frank's motion?
Essentially, the Frank's motion, that it would carry the fact that
Okay, so first of all, I do not have, and now, nor was it included in this motion or attached to the affidavit.
then I will draw my.
But typically with the Frank's motion, it's not the exclusion of things in that affidavit. But in the typical fashion, it would be the inclusion of things that may not be true. And then the court would say, well, if that's not true or suspect, and I take that out, is there still probable cause?
I'll file a Frank's motion.
Okay. You know, I think in 27 years, I had maybe 2 Frank's motions. Then Jerome Moore's case comes. And now everybody threatens them all the time. But I'm an expert, so that's okay. Doesn't matter. All right. So you're gonna. Okay, let's do it this way. Is there any additional argument on this motion?
Your Honor, the only additional argument that people have outside of what was prepared in the written response was that the trooper testified that there's no alcohol found in the defendant's vehicle or in the surrounding area. I believe that leads to that circumstantial case that people are arguing that the defendant must have been intoxicated prior to the trooper making contact with him on his way to this venue, and that under MCL 764.15, it was proper for this trooper to investigate and arrest the defendant, even though she never directly observed his driving. For those reasons and for reasons stated in the brief, the people will respectfully request this court deny the defendant's motions.
Your Honor, the vehicle, when the trooper encountered the vehicle, was in a safe position, on the roadway, was not in danger of doing anything. And matter of fact, the trooper thought it would fine for word of this my client in the vehicle. So there's no danger, there's no reason to arrest. One could argue that but for being told to move the car, he would not have been arrested. Nothing would have happened. But the driving that's involved in this motion was driving that she induced. The trooper told my client to move the vehicle.
Yes, but
that's the driving she saw, and she testified she didn't like the way he looked when he got out of the car. And everything stemmed from him driving that vehicle. What for her asking, but for the trooper asking him to move the car and the subsequent actions after that, he would not have been arrested.
But okay, maybe, but I think that you don't go far enough with the but for, because but for the fact that the vehicle is facing the wrong direction on an interstate, the trooper would not ask him necessarily to move the vehicle.
Which did. But the trooper did. I'm sorry.
Yes, because it's facing westbound in the eastbound lane on a major highway.
I agree. Also, it could have been towed out of there, not by driven. and it wasn't done, and everything that.
But hold on, I get you, Mr. Vincent, but on what basis would the trooper say, I'm just going to tow your vehicle? What she does is, it seems to me, is say, you need to turn that vehicle around so that it's facing a safe direction on an interstate.
I'm not disagreeing with that,
Okay.
but the fact that she did that, everything followed after that. Until she told him to move the car, for whatever reason, until she told him to move the car, he was not under arrest, even though there's some indication, apparently, that you can smell alcohol on him.
Well, when she's close enough and he's out of the vehicle, yeah.
But to me, the car facing the wrong way on the expressway on the shoulder road would indicate something's going on. But yet, my point is that none of the testimony about his walking and everything else happened after he was told to move the car and turn it around. And the judgment made, there was no testimony that this was done poorly, any sign of intoxicated driving or anything else, but yet he was pursued on that matter. The vehicle was moved from a position of safety by the trooper. My argument is,
Yeah, but hypothetically, and that's really what you're arguing. One might think that if the vehicle had been facing the correct direction, that the trooper wouldn't, that maybe the trooper wouldn't have arrested this defendant. But that's not because of anything that the trooper did. It's because of your client having that vehicle facing the wrong direction on an interstate.
I understand it, but that trooper had an opportunity to deal with all that. Instead, he was ordered, told, move your car around. After that,
No, she did have the ability to deal with it, and she did.
Right.
By telling him, turn your vehicle around.
and there was no investigation whether he was capable of doing that. No investigation whether he was drinking or not drinking. Nothing like that.
Well, which shows that the trooper did a good job because she didn't make any presumption whatsoever that he wasn't able to operate that vehicle.
Yeah, I'm not arguing the point.
What?
Not arguing the point.
Oh, yes, you are, but it's okay.
Fine.
I mean, I get used to it, but here's the problem, Mr. Vincent. I get what you're arguing maybe, but that the driving or what was observed by the trooper, you're indicating was induced by law enforcement. I say, okay, maybe, except that you don't go back far enough, because if you go back far enough, the trooper encounters a vehicle pointed the wrong way on I-94 and then asks the driver. And at that point, according to her testimony, she's not presuming that he's intoxicated. She doesn't have any belief that he necessarily is. Tells him to turn the vehicle around. He turns the vehicle around, but then she notices certain signs that indicate to her that he may be intoxicated. And it's from that point that she begins her investigation into drunk driving.
The trooper had my client move the car out of a position of safety.
Yeah. Okay, go ahead.
That's my argument.
Yeah, I got you, but I'm not sure that
I'm
a
arguing.
vehicle facing the wrong direction on I-94 is a position of safety. I don't know. I mean, we'll take a look at that, but
Anyways,
and the other thing is that you're also going to get into the definition of what constitutes a roadway, because it may very well be, and I'll take a look at it, that the shoulder constitutes the roadway also. I think by definition it does, but I will take a closer look at it.
was it in the lane of traffic? I'd make that argument.
Right, but the statute talks about a roadway. Roadway under the, as I'm recalling it, I haven't looked at it. roadway under the motor vehicle code has a very specific definition, which may include those adjoining parts of the lanes of travel, which would be the shoulder. So it may be that it's in the roadway in any event, but I'll take a look. Okay, so thank you for the argument. How long is it going to take you to file your Frank's motion so that we can?
A couple, 3 weeks.
Seriously? Oh, I mean, okay. Let's.
Good.
2 weeks. Okay, I'll give you 2 weeks. What's the 24th? Yes. I need the Frank's motion by July 8th. The people's response to that, if necessary, by, I'm just going to give you 1 week. I don't think it's going to take long. It's by the 15th. And then I will set a hearing on that Frank's motion, which give me a Wednesday. That's
I would give you July 29th.
well,
Would you like it before then?
I would.
July 22nd.
I can do it that day.
Yes.
All right. Then I'll hear the Frank's motion on July 22nd. And I will issue, if I don't issue it in writing beforehand, a decision on this motion. I'll just set a hearing date on that for July 22nd, but it's likely that I will issue a written in prior to that on this. Does that make sense?
Yes, just procedurally, because I think I was confused for this hearing, for the Frank's motion hearing date. Does the court want to do an evidentiary hearing that date, or is that going to be set if necessary at a later date? I just don't want to bring the trooper back out again 2 times like I did this time.
Well, except that the preliminary inquiry on the Frank's hearing, while I could hear argument, the court can either typically make a determination that whatever the defendant claims is missing, not missing, whatever, that I could make a determination at that point that I still have probable cause, if you're following what I'm saying. So I'm not sure. I don't think we would necessarily need the trooper, because if the court makes that determination that there's not probable cause, then we would have to have a hearing, or that's something, because what Mr. Vincent argued, I'm not sure the trooper's testimony would be necessary. If there's something in that, and just so that it's clear, if there's something Mr. Vincent's claiming that is in that motion or in the affidavit that is untrue, and that the truth of that, well, it could be one of two things. He's claiming something is untrue. If it's untrue, and I say, okay, I'll give you the benefit of the doubt, it's untrue, but I still have probable cause, then I'm not going to need testimony. If, however, the validity of the search warrant would hinge on the truth or untruth of that statement, then I may need the testimony of the trooper.
Understood.
Okay, that's the only way that I can really answer that. Why? The trooper said she doesn't want to come back here? Is that, no, is that what she said? Was she really critical of, like, it was Alan, wasn't it? That I get it. Okay.
My will be search warrant of 4 corners. So I'm trying to help the trooper not to have to come back, even though I know she's dying.
I know, no, you don't want her back because she doesn't really help you a lot. It's just put it that way. I mean, self-driven, it just doesn't help you. I will make a determination if we need to trooper back. How about that?
Thank you.
And then we'll work around that. Anything else?
Nothing.
All right, thank you. Thank you, Trooper. We still, court stands in recess.
Persephus, Elvendale, Gab, Ward. See here? No, it's okay. 26W843-043. Do you see him out there, Heather?
Judge, he's trying to join right now. Zoom is very slow. I don't know why here he comes right there.
Okay. Mr. Ward, you have to start your video, unmute, and state your name, please. Mr. Ward, you need to start your video, sir. You unmuted now. Now start your video, bottom left-hand corner of your screen. People against Trumbo. Brandon Allen Trumbo. 26W843-216 A and B. Come on, right to the podium and tell me your name, please.
Hello?
Stay right there, Mr. Ward. Just stay right there. Keep mute and don't say anything, please. Your name?
Brandon Trumbo.
You're charged with driving while unlicensed or without a cycle endorsement and speeding. You have the right to an attorney. I'll be happy to provide you with one at public expense. If you would like one, would you like one?
Sir.
All right, so I'll go ahead and arraign you and then I'll send you to the prosecutor. Fair enough? On May 30 of 26 at 10 p.m., it is alleged that you did operate a motor vehicle in Allen near King and Woodhaven while you were unlicensed. That is a misdemeanor punishable by up to $500 in fines, 93 days jail costs, or all of those. Do you understand that? I can't hear you.
Correct.
And then you're also charged with speeding going 1 to 5 over. That would be a 1-point civil infraction. You understand that? Did you sign, read, and understand the advice of rights? Yes?
Yes, sir.
If you plead guilty, you'll be giving up all those rights. There will be no hearing or trial. Do you understand that? All right. You still wish to waive your right to a lawyer? You want a lawyer?
No.
Okay, so you're going to represent yourself. Is that true?
Correct.
Not guilty, please enter. I'm going to enter a plea of denial on the civil infraction. I'm going to give you a $500 personal bond on the drive while unlicensed. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. You go sit out in the hall. And we'll take the file to the prosecutor. And the prosecutor will call you out, okay? And then he'll call you in, speak to you, and then either way, you're coming back in front of me. Okay?
Sounds good.
I can go right out there. Thank you.
Thank you.
Mr. Ward, Persephus Delvendale Gab Ward, 26W843043. Your name again, sir? Where'd he go now?
He was just up on the video and now it's showing that he's back in the waiting room. Let me try bringing him in again.
Sherelle Nicole Carter. 26W841067, 26W841163. Your name, ma'am? You're charged with violation of parental responsibility law. And you're also charged with a second count, a violation of parental responsibility law. One was issued on or about February the 20th of 26. The next one was issued on or about March 31 of 26. Carter Glabon is the person that supposedly that was not required to go to school. You have the right to a lawyer if you want one. I'll be happy to provide you with one at public expense right now. Would you like a lawyer? So you're charged with violation of parental responsibility law. There's two different charges. And it is essentially that you failed to ensure the regular attendance of Carter Glabon. I'm not sure how old he is, but that is the charge. If you plead guilty or if you're found guilty, you could be sentenced to the following. These are just the maximums, up to 500 fines, 90 days jail costs, or all those. Do you understand that, ma'am?
Yeah.
And you just sign, read, and understand an advice or rights form here today.
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. You understand that? You still wish to waive your right to a lawyer?
Actually, I was
I'm sorry?
yes, I do want.
I'm going to not guilty plea. You posted bonds. Why didn't you show up here before?
I didn't even know that it was working out for the school. Carter, it has autism.
Okay, so you should talk to your lawyer about that. I just asked why you didn't show up. I'm continuing. You had posted $300 on each of these after you missed a couple times. You cannot leave the state without the consent of the court or violate any law unless the hearing court is directed. You do have to ensure that your child attends school with no unexcused absences. I realize it's the summer now, okay? Give this to the You go out in the hallway, they'll set you up, okay? Jeremy Allen Schultz, 23W830846. Mr. Schultz, you can come on up to the podium and tell me your name.
Jeremy Schultz.
You're charged with retail fraud. You have the right to a lawyer. Be happy to provide you with one at public expense. Would you like one?
No.
Want to represent yourself?
Yes.
You got 4 warrants out for your arrest. You don't do a very good job of showing up in court, sir. Judges don't like that. It is alleged you committed the offense of retail fraud in the city of Woodhaven, County of Wayne, at 21,000 West Road at the Lowe's store in the city of Woodhaven. That is a misdemeanor. It is punishable by up to $500 fines, 90 days jail under local ordinance costs for all of those. Do you understand that?
Yes,
You just sign, read, and understand the advice of rights.
yes, sir.
If you plead guilty, you'll be giving up all of those rights, and we're not going to have a hearing. We're not going to have a trial then. Do you understand that?
Yes, sir.
All right. Do you still wish to waive your right to a lawyer?
Yes.
I'm going to enter a not guilty plea for you. I'm going to set a bond. You posted a bond. Where you been?
I was incarcerated for the last 2 years.
Do you live on Chestnut still?
Yes, I do. With my mother.
All right. So I'm entering a not guilty plea. I'm going to let you go talk to the prosecutor. You cannot leave the state. So I'll continue your $300 bond. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. You're not to enter or go near 21,000 West Road in Woodhaven or any other Lowe's. You're not to have any contact with employees of the Lowe's store, the Woodhaven Lowe's. So you cannot write, phone, see, text, email them, or have anybody else do any of those things, except your lawyer can do that. No contact with prosecution witnesses. You're going to go out in the hallway. The prosecutor will call you in and you're all set. Any questions?
No, sir, thank you.
All right, good luck. All right, do I have Mr. Ward out there? This is getting a little,
He keeps popping in and out, Judge. Like I bring him in, he goes back. He just popped in again. I'm going to try bringing him in again. Like I spoke with him when he was first on here, so I know here he should be in there again right now. Mr. Ward, can you start your video, please?
Mr. Ward, I need you to tell me your name, please. You need to start your video. I hate to make you come here from Buffalo, but you got to learn how to get on here. I can't keep calling your name only to have you disappear. You have to start your video in the bottom left-hand corner of your screen, sir. Malott, Bradley Jacob Malott, 25W83848. Your name? Brandon. You got another retail fraud pending.
Or anything like that sort of thing.
I'm not going to dismiss this case. I'm just going to make a note that you're not compliant, have case pending in Southgate, 28th District Court for retail fraud. I will adjourn the review hearing pending the outcome of that case, okay?
Thanks, sir.
It is not to say that you're not going to have this conviction entered even if you plead to something else. Do you understand that? Not going to cover it anymore. We'll adjourn we will adjourn this to a date. Give me a date at the end of July, will you please, Heather?
We could do July 22nd at 8:30.
Yes, at 8:30, okay? July 22nd at 8:30, that will be the new review hearing. All right? Any questions?
No, you're.
All right. We'll see you back. You can go down the hall, get your notice. Mr. Ward, this is Delvendale, Gab, Persephus, Delvendale, Gab, Ward, 26W84303. You have to unmute. All right. Tell me your name.
My name is Ward.
I need your name again. I didn't get, you have to state your name again.
My fault. I said Ward.
I don't know why the connection's so bad. Tell me your name again.
My name is Persephus Ward.
Okay, good. That was a good connection. Now listen to me very carefully. You're charged with littering from a motor vehicle. You have the right to a lawyer. If you want one, I'll give you one. Do you want a lawyer?
No, I just voted guilt. I did it, you know.
Go ahead and
admitted
arraign
to
him.
it.
I'll send you to the prosecutor. It is alleged that you did operate a motor vehicle on I-75 southbound near Weston Woodhaven at 3:57 in the morning on May the 24th of 26. And they think you were littering. That is a misdemeanor punishable by up to 500 fines, 90 days jail, costs of all those. You understand that?
You said what?
You understand what I said? They think you were littering from a motor vehicle on that date. They think you threw a tissue out the window. They pulled you over. They charged you with littering. These are the possible penalties. I didn't say they were going to happen. It is punishable by up to 500 fines, 90 days jail, costs are all those. Do you understand that?
Yes, I can hear you now.
Did you understand what I said, sir?
Tonight, 90-day jail, and then you said for I was
Do this like this. You're going to have to go somewhere else in the future. Listen to me very carefully. I can't do this. I'm not picking you up. You're not hearing me. I don't know where you're going to go. I don't need you to fly to Detroit, but I'm not going to have you in the same location because it's not working. Wherever you are, when we reschedule the court date, you're going to have to move to a different location. I don't care where it is. I don't know what to tell you, but I cannot pick you up. I cannot hear you. You cannot hear me. So I'm simply going to adjourn this, Heather. We'll adjourn this. We'll set a new arraignment and pretrial date. And you're going to have to be in a different location and you're going to have to know how to show up. Do we understand one another? Of course we don't, because you can't hear me. Heather, chat with him. Give me a new date, please.
Okay, do you want to just do the Monday, July 13th at 1 o'clock?
Fine, July 13th at 1. Chat with him and tell him that, okay?
Okay.
He's going to have to be in a different location, I think. I don't know where he is, but we can't pick him up. Thank you. Samantha Jean Height, 26W841554. Come out to the podium. Destiny Henry, you're going to be next. Where'd you get districts on next 5 then?
Yeah, it's up.
Huh?
It's up there.
Your name, ma'am? You're charged with the violation of criminal responsibility law. You have the right to a lawyer. Would you like one?
Yeah.
On May 29 or 26, they think that you did the offense of retail fraud by failing to ensure the regular attendance of your child, Emmett Height at Woodhaven Upper Elementary School at 24825 Hall Road in Woodhaven. That is a misdemeanor punishable by up to 500 fines, 90 days jail, costs are all those. Do you understand that? Yes?
Yes,
Did you sign, read, and understand the advice of rights form?
yes, that's right.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that? You still wish to waive your right to a lawyer. I'm entering a not guilty plea, $500 personal bond. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. You're to ensure the regular attendance of your child. I realize this is summer.
Yes.
So maybe the child isn't in school now, but if this somehow pushes out, you're to make sure that child attends school. You understand that?
Yes, sir.
All right. Any questions? All right. Good luck. You're going to take that file to the prosecutor. Say the name again, Mr. Zone.
Who Heights one prosecutor?
Yes, she's representing herself.
Just have a seat in the hall.
Did we ever get that?
Now,
Okay. Still waiting the blood results, Mr.
They're in there, Judge.
They are?
Yeah, they told me they were in there. And apparently they were in there. I'm sorry, I have to speak with the judge.
Let me see. Are they in the pre-sentence report?
I'd be there too, Judge. But it was in the file. They found it after I left here that Sunday.
Oh, they did? People against Purnell Lamar Fountain, 26B150239A and C. Let me check. I ran.
I didn't bring my reading glasses to you, so
That's all right. I ran through this real quick this morning. I didn't see them in here, but let me find them.
I didn't know that after I left here, they called and said they're gonna file, come back, but he was on his way back to Toledo. He's on Zoom this morning, Your Honor.
Okay, sir, your name?
Purnell Fountain.
Judge Edward Zelenak for the defendant. I appreciate you allowing me to have him appear by Zoom at the last moment. He's from Toledo. We've had 2 false starts on sentence, and he has a family emergency this morning.
That's fine.
I think, Mr. Fountain, what was your blood alcohol level, Mr. Fountain?
I believe it was like 0.14, I believe.
That was a blood draw, Judge.
All it says is that in the complaints, and they didn't do.
They drew blood.
I know, but as of April the 23rd, the Brownstown Police Department still didn't have them. They were still pending. So then we took the plea on the 22nd. Sadie, go see if she said so that. So I had her get a hold of them this morning. I don't want to make a bigger deal this than it is, but I still want to know for sure what, it sounds like that was the PBT result. So let me just double check and make sure we have them. She said she was going to send them. So oh, you're fine. Stay right there. Let me see. I think that she should be
Ms. Foley's not here today because she remembers too, because she called me as we got in the car, but it was too late.
Who's here for Brownstown today?
Miss Foley's here. She would know because.
Oh, she's here?
Why? I don't know. She's always here.
Yeah, I thought you said she was.
Do you want me to call the conference room and see if she's in there, Judge?
Yeah, and ask her to come in here.
Okay.
I don't have them either, but I saw the results because they called me when he was charged and she sent him a correspondence.
Okay.
I know it wasn't that high.
Well,
I mean, that is high. I'm sorry, but when I started.
No, but I get it. I get it. Here they are. So I don't need her. He had THC in his blood. I don't even see where they have a. Call in the prosecutor, will you?
She's on her way over to you right now, Judge. I got a hold of her.
Thank you. All right, so let's just wait for her and we'll go from there. They didn't send me any report other than saying he had THC in his system.
Shall I have a seat, Judge?
No, you're good. Just wait right there if you would. It won't take. Miss Foley Carter, your name?
Caitlin Foley Carter, Brownstown Township.
I took her to drive a plea to operating while impaired. It was due to the consumption of alcohol. I've been trying to get the blood results from Brownstown. They sent the packet over. I only see where the THC in his system.
Your Honor, it looks like he had alcohol of 0.149 grams.
Is that? Well, all they sent was the supplemental reports. This report was completed, it looks like, on April 13th. So I don't have an original report regarding alcohol. Do you have that?
Your Honor, I did also send it over to the court after this was adjourned.
Okay. All right, good enough. So, yeah, if you could just give me a copy for the file, that's fine. All right, Mr. Fountain, I'm sorry about this confusion here. State your name again, please.
Purnell Fountain.
Mr. Zelnick, have you reviewed this report with him, and are there any material additions, corrections, or deletions?
None at all, Your Honor.
And for the record, she's handing me this report. It does say 0149. So go ahead. I'm sorry.
I'm delighted that my client has a better memory than I do.
Right.
Your Honor, I see nothing. This is a true first offense. I see nothing else to add. He's in Ohio and he said he's prepared to come once his mother's squared off, perhaps tomorrow, to pay the fines and costs in full and arrange with probation if you would allow him to come meet with probation tomorrow. Is that correct, Mr. Fountain?
Yes.
That's assuming you don't incarcerate him.
No, I got it.
So he'll be here tomorrow to complete the matter in the court recalls. He was here twice. Once I was out of town, once we couldn't find the blood results. So I apologize.
How far,
This time he couldn't make it.
how far is Holland from here? Is it outside of Toledo?
Yes, sir.
So it's about an hour, is that right?
Little over an hour, about hour 7, hour and 10 minutes.
All right, good enough. Is there anything you would like to say, sir? You're all set.
Thank you.
Thank you.
No,
Anything
sir.
you- All right, I'm going to place you on probation. I'll adopt this report, 12 months. You can leave the state, can leave state without consent. You live in Ohio. You cannot violate any law or ordinance if you change your address, place of employment, or home telephone number. You do have to notify probation. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume one of those. You're to submit to chemical testing, PBTs and ETGs monthly or more on demand of probation. Kratom poppy seeds and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I do want you to attend the Victims Impact Panel. I do want you to attend the Substances and Use Group through Class A Training Center. I'm not going to make you come here for the court work program. I'm going to let you do 4 days jail credit, 1 serve 3, and I'll let you do those by way of community service. And I'm going to give you until August the 15th to complete 24 hours of community service. You can do that at any nonprofit organization of your choosing, okay?
Yes, sir.
Fines are $300, cost $200, 75 victims' rights fee, $50 justice assessment, 6 1/4, screening fee 60 for 685. Probation fees are $240 for a total of $925, and you have cost of recovery of $218 for a total of $1,143. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. You may be eligible for early discharge. You get everything done, no violations within the preceding 90 days by statute. You are entitled to early discharge. So you can make a petition after 6 months. So sometime around Christmas, okay?
Yes, sir.
All right, so I think I'm going to just say pay by tomorrow. Is that you can pay in full by tomorrow? Is that what you said?
You can pay that by tomorrow in full. Is that correct?
I don't know if I'll be able to pay it in full, but I will be able to get a big chunk of that taken care of tomorrow. But I know for sure I'll have it all the way paid next Friday when I get my check. Absolutely.
You know, Steve, what's the big?
Listen, I'm just going to give you until a week from Monday to pay it in full. You going to be able to do that?
Yes, sir.
So I'll make that, let's see, and that will be on what day is that? July 6th. You just pay in full by July 6th. You better check over there. I don't know if, I'm sure they've got people that are going to be there tomorrow. But I want to make sure he's not sitting around either. On the defective equipment, fines and costs are $120. Okay, so $120 on that. And I'll say pay that by July 6th. If you need more time, no problem. Call the court. We'll go on Zoom. I'll give you an extension. Okay?
Yes, sir.
All right. I wish you well. Thank you, Mr.
Thank you,
Zelman.
Mr. Fountain.
Thank you.
Like with your mother today, please bring a big chunk when you come here tomorrow. I'll check the probation.
All right. Have a good day.
Thanks a lot, Mark.
Thank you very much. All right. Is Destiny Henry here? Destiny Danier Henry.
You want to go over to the victim?
Pardon me?
You want to go over to the victim?
Not yet.
Okay.
Your name? All right, you were in front of me and I ordered you not to have any contact with the victim as part of your bond conditions that I entered on May the 27th. And I have here in front of me a charge that alleges that you failed to refrain from having contact, direct or indirect, with Michelle Newsom. If I find you didn't have contact, you'll be exonerated. If I find you did have contact, that is, you either called her, wrote her, saw her, texted her, emailed her, phoned her, I don't care what, any one of those scenarios, then you could have your bond could be forfeited, the relief revoked, and a new bond set. Do you understand that? Do you have a lawyer representing you on this case?
Carmen. He's not.
Did you speak to Mr. Carmen today? My apologies.
He is out there.
I'm gonna need him in here. Why don't you have a seat at the table right behind you? Sean Eric McKenzie. 25F23230. Your name?
Sean McKenzie.
Why'd you wait so long to take care of this?
To be totally honest, I don't know what this is needed for. I'm here for another matter.
You got a ticket for impeding traffic back in January of 25. It was out of flat. They think you were operating on West Huron River Drive.
Yeah.
Hang on. You went into default. We show caused you. Didn't show up for that. Back in May of 25, I issued a bench warrant, May the 20th, 25. Then it looks like you came in here on May the 20th of 26. We canceled the warrant and you must have posted the bond. Is that what happened?
Yes. Yes, sir.
Why didn't you show up on this? Don't tell me you forgot. I forget. Why didn't you show up?
I tend to avoid situations like this because I have to call off work and my work isn't exactly understanding.
Well, it's a reason. It's not a good reason.
I understand.
But it is a reason. It's not one I'm going to buy. Okay? Heather, does he still owe $237?
272 is his balance.
You have another 35 with you?
Okay.
Good. Trying to pay $265 total. Balance is waived. I trust that I jumped the gun here a little bit. I trust that the bond is in his name, right?
Let me take a look. Yes, it is. He has a bond of 237.
Good. You add another 28 on your credit card and that'll take care of it. Good luck. Have a good day. Go down and deal with them. Stop doing that. It's not a good idea. Thank you.
Thank you.
Destiny Danye Henry, sorry. 26W842-495. Come on up again, ma'am, and state your name. I didn't realize you had a lawyer already, Mr. Carmen.
Michael A. Carmen, because creating performance at the ground.
So I just explained the charge to her. My apologies. I didn't realize you were on this. For failure to refrain from having contact, direct or indirect, with Michelle Newsom. And ma'am, and I did explain to her that if I find she had contact, I could revoke her release, forfeit her bond, and set a high cash bond. And that is the charge. And I'm asking you at this point, how does she wish to proceed? Does she want a hearing or does she wish to plead guilty?
She's going to plead not guilty, and we're asked for a hearing, which should be very quick and simple.
Okay. Let's call in the Woodhaven prosecutor and let's get the victim in here. And you can have a seat right behind you, man. Is Albaraki yours? Which ones do you have? You got Mr. Patrick, right?
Yes, I have that. One person is here. Who's mine? Hello.
All right.
Hello.
Jeremy Allen Schultz, 23W830846. Your name?
Jeremy Allen Schultz.
All right, so you just met with the prosecutor and you are going to plead guilty to attempted retail fraud, correct?
Yes, I do.
So it says older case, defendant since charged has numerous multiple jail sentences.
Yes, Your Honor.
Your appearance?
William York on behalf of the people of the city of Woodhaven. I discussed this matter at some length with Mr. Schultz. He has served jail sentences in Eaton County, Macomb County, Oakland County. He suggests, although I wasn't able to confirm myself, that he did attempt some pleas by mail over the course of time. He has retained Jeffrey Oda for other matters. He came to this court indicating he wished to represent himself. And so the people felt that the ends of justice would be met by an attempted plea.
And that's fine. I wasn't actually calling you in on this one.
Oh.
But you said, and you don't have any objection to a suspended sentence.
Affirmative.
You didn't agree to that.
No objection to a suspended sentence, but it's not a killable plea, if you will.
It just, you're just telling me I don't have any objection if the court just imposes fines and costs.
Affirmative.
But there's no sentence agreement between you.
No.
So do you understand I can go along with that, but I don't have to go along with that?
Yes, sir.
And you understand that this is punishable by up to $250 in fines, 45 days jail, costs are all those?
Yes, sir.
And did you sign, read, and understand the advice of rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that? You still have the right to a lawyer. If you want to change your mind, I'll be happy to provide you with one at public expense. Do you understand that? You still wish to waive your right to a lawyer?
Yes, sir.
Anybody forced you to do that?
No.
To the charge attempted retail fraud, how do you plead?
Guilty.
On May 17 to 23 at 8:29 a.m., where it blows at 21,000 West Road in the city of Woodhaven.
Yes, I was.
And did you take out some kind of a mower, an ego mower, it says, while in the store and walk past the register without paying for it?
Yes, I did.
And was that valued at $649?
Yes, sir.
Anybody forced you to plead guilty?
No.
Are you on probation or parole?
Yes, I am on probation.
Were you on probation on May 17 of 23?
No, I was not.
All right. Okay, I'm going to accept your plea to attempt retail fraud, dismiss the retail fraud. I'm going to still order a pre-sentence report. I want to get everything, I want to know a little bit more about this. Pre-sentence report, sentence date. I already told you the bond conditions. We'll give them a sentence date. Heather.
We can do this one on, how about July 22nd at 8:30?
July 22nd at 8:30, okay? So you're going to go down the hall. They're going to give you your paper notice. Then you're going to go over to probation where you'll be interviewed. Any questions?
No, sir.
Okay, good luck to you. Thank you. Now, this is the one I was actually calling you in on. Destiny Danier Henry, 26W842495. I'd like the victim in here. I have arraigned, Mr. Carmen, your name again?
Michael A. Carmen, P7384. That's the defendant, Your Honor.
Ma'am, your name?
This man,
And ma'am, your name
Michelle, son,
and your appearances?
Jessica Oda on behalf of probation.
William York on behalf of the people of Woodhaven.
So Mr. Carmen has advised me that his client wishes to have a hearing. So I'm going to go ahead and swear in the victim as well as Ms. O'Donnell. And we'll go from there. Both of you raise your right hands, please. Do you solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got? Ms. O'Donnell?
Yes, sir.
Ms. Newsom? All right. John, why don't you take that garbage can over there for her, please? I'm gonna ask you to throw your gum in there, please. All right. I don't care how we start. You can go ahead and start.
Because I have one bond violation I issued on June 22nd. I have one bond violation is failed to refrain from having any contact, direct or indirect with Michelle Newsom. I was contacted not only by the victim, but by the detective on the case for Woodhaven PD regarding that Destiny, Miss Henry, had contacted the victim via text message. The text message is from an iCloud account that I do have, that I do know is Miss Henry's account, which she communicates with me through that account. It looks like she sent a text message to the victim, Miss Newsom, June 21st. There's only one text message that was received. The text message relates to Miss Henry's child. It states that her son will be with me all July 4th weekend. That is the one text message. According to this, the no contact order states that she's not had any contact with her except through their family court proceedings. As of right now, there's no family court order in place. They have a hearing scheduled for July. The only court order that's in place, to my understanding, is regarding a Judge Hessen case. Ms. Henry is also on probation with Judge Hessen for a domestic violence case. In that no contact order, Judge Hessen issued a no contact order stating that she's not to have any contact with her son's father, who is Jason Haney, who is the victim's son. It also states that the no contact order, if people include their child custody, should be done through third parties, meaning that Destiny's parents should be communicating with Miss Newsom and keep the parents out of the situation, that it's just the grandparents that should be communicating regarding the child's custody agreement. That's why I issued the violation regarding this.
I'm sorry, I'm a little confused about the relationships with everybody here.
Yes. So Miss Henry has a child with Jason Haney. They have a son together. Miss Newsom is the mother to Jason Haney. So she's the grandmother to Miss Henry's son.
All right. And the content of that was the child will be with me
July 4th, yeah.
July 4th.
That was the text message that was received. It was regarding her child. But again, as far as I'm aware, no contact order states that they're only to be communicating through third parties.
If I may, Judge.
Yes.
Grandmother, so to speak, is the victim in the stalking case that is before this.
That is correct.
Do you have any questions of Ms. O'Donnell, Mr. Kerman?
I would just ask, I believe you already said Ms. O'Donnell, but there's one sole text message at issue.
That was the only one that I received from the victim. That's correct.
And it states, I believe, Deborah will be with me all July 4th weekend.
That's correct. It is regarding her child.
Said this was June 21st.
I'm sorry, let me double check. June 21st, it's not.
At 12:34 p.m.
Yes.
No further question.
Do you want to add anything, Ms. Newsom? I issued this entered the bond, I should say, issued the bond on May the 27th. Is that the only contact that you've had?
Since that hearing, yes. Before, tons.
Right.
Since the hearing, just that.
Okay. Do you have any other questions, any other testimony, anything you'd like to say, ma'am?
I just want her to follow orders. Me and her mother is doing communication for custody. I do not want any contact with her.
Anything else?
You know, I would ask Ms. Newsom, Deborah is my client's son, correct?
Correct.
And your son's son?
Yes.
Okay, and there's currently a proceedings for child custody in the Wayne County Circuit Court.
Correct.
And just involving Deborah, correct?
Yeah.
Okay, thank you.
Does your client wish to testify?
No.
All right, any argument at all?
Does not wish to testify, Your Honor.
Any argument anybody have?
Your Honor, I would simply indicate that, I believe the court was clear. There is a highly functioning relationship between the two grandmothers. The other grandmother is in the back pew. If you could raise your hand.
Okay.
So the communication is highly effective to uphold any, what if any, parenting time the young lady wishes. She violated a court order. There was no reason, because there's no breach of communication between these two grandmothers. In essence, Judge, at least as far as looking after Devereaux, these two grandmothers are on the same team and they have his best interest at heart. The whole reason for being in court on this matter was the stalking for this young lady. So I believe this does beyond or by the standard of proof before the court for this, which is not guilty on a reasonable doubt. I believe it does constitute a violation, and I would ask the court to make such a finding and leave any sanction to the court's obvious discretion.
This is actually very simple. It's being made out to be more complicated than it needs to be. My client does have an ongoing case with Judge Heston. That's dealt with bringing up the forward. As far as in your court, Your Honor, on the bond sheet, but you specifically wrote, with an exception to the no contact order, it's a little difficult to read the handwriting specifically, but I believe that it says, except in conjunction with custody proceedings with circuit.
In conjunction with circuit court proceedings.
Circuit court proceedings.
I think what I meant was, I know what I meant is that if she runs into her in the circuit court, that's not going to be deemed a violation of the no contact. If there's something that happened in the order, I don't know exactly what the circuit court order was. Does the circuit court order provide for any kind of contact?
No, my son had told the circuit court that I did not want any contact with her because of prior instances that I was willing to mediate for him since they couldn't do the mediation because of prior charges. So he said that I'm willing to speak with her mother and do communication exchanges. She agreed, and that's just how that.
Look, there is no question that you violated the no contact provision. You had no right to go direct her. No, I'm not going to violate your bond and lock you up for this, but I'm going to caution you. There's not to be any contact at all with Ms. Newsom. Do you understand that? Yes? I can't hear you though. I find that you violated the no contact provision. You had no business having direct contact with her. So I'm telling you, if it happens again, I'm not going to hesitate to set a high bond. And you'll be sitting in jail awaiting trial on this. Do you fully and completely understand? I can't hear you.
So just for clarity, just for what you wrote on the bond sheet there.
Yeah, it says, except in conjunction with circuit court proceedings. This has nothing to do with a circuit court proceeding.
Well, I mean, my client indicated that to me it did because they had a circuit court proceeding scheduled on July 13th. She was just checking, I mean, it's custody, it's visitation.
But she's not a party to the circuit court proceeding. Miss Newsom here is not a party to that.
But my client has indicated that she's very involved in it.
It might, well, because I was saying, well, I know what I didn't say except in conjunction, except to effectuate visitation or custodial exchange with minor children. I did not say that. What I was saying with my except in conjunction with circuit court proceedings, if she goes and she's there, I'm not going to have somebody come in here and say she violated the no contact. She showed up, she was there, and the defendant was there. That's all I was trying to clarify.
I understand, and that's the clarification I was seeking.
I understand. But this young lady knew that. And I'm telling you, you're playing with fire. Do you understand what I'm telling you? I can't hear you. All right, so are you guys, I'm going to find that there was a violation. I'm not going to change the bond. I'll continue the bond. Are you guys going to go and try to pre-try this?
Yes, sir.
All right, good enough. That's what I'll do. And when you come back in front of me, maybe you're soft-spoken. We got to pick you up. You got to have your voice about 40 times the decibel level that you have it now, okay? Thank you very much.
Thank you.
Thank you. Are you ready on Patrick, or do you want me to go on to something else? It's up to you.
Say it again.
You want me to do Patrick, or you want to go on to something else?
We can do Patrick. He's great.
This is a tough one. I'm just going to be honest with you. Accepting him, but I'm likely to send him to jail. I just want to know, I want you to know that. Michael Edward Patrick, 26W8428738.
Michael A. Carmen, B73824. I'm happy to find your honor.
Your name?
Michael Patrick, your name?
So I just want to be upfront with everybody. I'm totally in favor of accepting him into sobriety. But this is your fourth drunk driving in 10 years. You had him at 16, 19, 21, and 26. So the likelihood of you not going to jail today, Mr. Patrick, is next to nothing. I just want you to know that. Before we go on, have you had a chance to review the report with him, and are there any material additions, corrections, or deletions?
Your Honor, yes, I have. No, I don't believe so at all. Actually accurate. My big thing was with this, my client lost his wife of 36 years about probably happened almost exactly 1 year ago, and had a really hard time, dealing with that and, relapsed unfortunately, but he says he's been in the, I guess it's called bond phase for a month and has been doing great, really just trying to attack his issues, which he doesn't deny head on. I think he's a perfect sobriety court candidate. I really do. He does have some priors, but he's got three sons that he's married to adulthood. He realizes that this has been a problem, but I think his relapse is understandable. Suddenly losing his wife at 59 years old, so I would just ask the court to take that into account. I'll let him say anything else he'd like to.
Sir, what would you like to say?
I'd just like to say, Your Honor, that mistake that I made drinking was on Mother's Day. I just had a really hard time with this, and I made a super bad choice. I didn't drink. I haven't drank since my last one. Not one drop of it. I was totally alcohol free until Mother's Day, Your Honor. I've lost like 50 pounds this year. I'm ashamed of myself. I'm sure my wife's probably looking down on me right now and not very happy with me. It kind of obsessed me. But, I just like the opportunity to show that I can do the sobriety board and do it all to the end. I could do it.
And you're just emphasize what's in the reports. I'm sure you reviewed. You've been testing twice weekly for chemical and alcohol, all negative tests, and no sober link device violations, and all blows being timely, and not a single reading for alcohol. So in over almost 5 weeks.
This is a tough one. The last thing I want to do is cause somebody to go backwards in their recovery, and it seems as though it's done really well. But let's take everything that you said at face value. Let's say you were having a hard time. I believe you.
Still having a hard time, Your Honor.
So you decided to drink. You took the extra step of driving again when you had 3 of these. They should have charged you with a felony. I don't know why these departments are not doing it. I don't know. They should be. The law says 3 in your life. You've had 4 in 10 years. Even under the old law, this was a felony. Now, I can't remember how long the new law has been in effect. When they change it, I black it out. I take it out of my mind. But it's been at least 15 years. 2 years probation. I'll be happy to accept you in the sobriety court. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. Change your address, place of employment, home telephone number. You must notify probation. You have to report as directed. You're to comply with all agreements, guidelines, and requirements as indicated in the sobriety court participant handbook. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. You're to submit to chemical testing, PBTs and ETGs on demand of me and or the probation department. Pay all costs associated therewith. You're to submit to chemical testing, PBTs and ETGs on demand of probation. You're to complete 60 additional days on the sober life device. After completion of your jail term, you're to attend AA 3 times a week and provide written proof of attendance. You're to obtain an AA-NA sponsor. You're to attend all substance abuse treatment at a facility approved by probation and would provide written proof of attendance. You're to attend the Victims Impact Panel. You're to attend and complete the Armed Specialty Court Weekend Program. You report to sobriety court status review hearings with me every 2 weeks. You'll meet with probation in the off week. You're to obtain and maintain employment with proof provided. Actually, you're completely retired, right? So I'm not gonna require that. Not to require that. You're retired at 59 or 60 now. You're to pay fines in the amount of $200, costs in the amount of $300. $75 victims' rights fee, $50 justice assessment, and a $60 screening fee. So that totals $685. You're to pay probation fees of $480. That brings your total to $1165. You have $360 in sobriety court fees, bringing your total to $1525. You also have, this was a breathalyzer, right?
Yes, sir.
$150 in cost of recovery. So your total $1675. I'm going to order. I'm going to order 24 days jail. I'm going to give
I'm sorry, I'm stopping.
24 days jail. I'm going to give you credit for 1. I'm going to allow you to serve 6 on the court work program. There's a $35 a day charge for that for a total of $210. So your total fines and costs amount to $1,885. You're going to serve for 17 days now. Dale, it's a gift. It's only because you've done so well. 4th offense, I can't live with. I'll cut it down like you'd have done 90 or 65, 75, whatever, close to 90 under this charge. And they enhanced and gone with a felony, which they should have. You'd have served a lot more. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. So you are in custody.
Your Honor, can he have a day or two to get this affairs in order before he reports?
I'm sorry.
My house is open. I have nobody to help or to square things away home.
If you need a couple hours, I'll let you go. But you're coming back here by 1 o'clock. So, do you understand?
Yes, sir.
Can't expect to keep doing this without severe consequences. Like I said, there is no way. I'll just say that jail term to begin at 1 p.m. Don't make me send the police out for you. Okay? And again, you have 21 days to appeal, 14 days to apply for a court-appointed lawyer. What about the money? When can you pay the money? I can give you.
Judge, he does have a bond of $750.
Yeah. So He's not discharged. I'm trying to remember that rule again. The new rule. I think that the court keeps it 10%. I think the court keeps it. So you have 675 to apply. And then I'll be glad to set you up on a payment plan.
Your Honor, I will take care of that today, sir.
All right, I wish you well. I really do.
So Your Honor, is that balance 1210?
So after the 675, he's going to have 1210. Okay?
Today we come back.
Thank you. Have a good day. Good luck, sir. We'll see you by 1. Alvaraki, Tabark, Jasm, Alvaraki. 267842950 A and B. Good morning, ma'am. Your name?
Good morning, Your Honor. My name is Tabark Jackson Alvaraki.
All right, you charged with driver license expired. You have the right to a lawyer. If you want one, I'll give you one.
I'm okay.
I'll go ahead. So you waive your right to a lawyer?
Yes.
Okay, so I'll go ahead and arraign you and send you to the prosecutor. They think that you did operate a motor vehicle on I-75 southbound near Weston Woodhaven, May 28 and 26 at 7:19 p.m. with an expired license. That is a misdemeanor punishable by up to 100 fines, 90 days jail, costs, or all those. Those are just the maximums. 2 points would be added to your record. Do you understand that?
Yes, sir. Yes, Judge.
And did you sign the advice of rights and read and understand the advice of rights? You plead guilty, you will be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes, I understand.
You still used to waive your right to a lawyer.
Yes.
I'll enter a not guilty plea, $100 personal bond. You have a second charge of 75 and a 70 limited access. That's a civil infraction that would go on your record, but it's 0 points. Do you understand that?
Yes, Judge.
Okay, so we're going to take this to the prosecutor, John. In fact, Lieutenant Toller, you can take this right to the prosecutor, and this lady's going to represent herself, okay? So as soon as you're done there, you come on back and we'll handle the rest in here. Okay, thank you.
Thank you.
LaPalme, Tyler LaPalme, Tyler Edmund Lewis LaPalme, 26W843-185. Mr. LaPalme, how are you? Your name?
I'm good. How are you?
Your name?
Tyler LaPalme.
Mr. Schwartz, how are you? Your name?
Seymour Schwartz, Your Honor. I'm appearing on behalf of the respondent, defendant, whatever he is. He's a pretty good kid. We'll take the deal.
So he's going to plead to impeding, right?
He is.
To that, and they're going to dismiss the amber light?
Yeah, we thought it was pink.
Charge impeding traffic, Mr. LaPalme, you plead responsible or not responsible?
Responsible, Your Honor.
Accept the plea, dismiss the amber light violation, which is 3 points. Your lawyer saved the 3 points. 150 is your total. Can he pay that today?
He can.
33court.com. Have a great day, Mr. Schwartz. Good to see you.
Thank you. You too, Judge.
Guzman.
See you later.
Bye now. Kristen Fern Guzman. I'm going to need your lawyer in here too. Did you meet with your lawyer?
Yeah. Just stepped out.
Okay, so we'll get him back in here. How's that? Okay.
He's coming in.
Carter, Sherelle Carter, 26W841163, 26W841067. Come on up here real quick, ma'am, and tell me your name. Did I give you a lawyer?
Yes.
Who's your lawyer?
It was the lady.
Okay. Okay, look, I'm gonna.
Hold on. You wouldn't have to give you Carter if you gave Carter.
I give it to Deanna.
I gotta find out what she's in.
All right, why don't you have a seat too, ma'am? I'll be right with you. Who do you have? Guzman. There's Kristen Fern Guzman, 26W841847. I don't know if the victim is here, but I need to apprise you of something. Ma'am, your name?
Kristen Guzman.
I'm responding D73824 on behalf of the 21.
I don't usually fight him on this, but all these charges she's got pending, and she had an assault and battery, and there was a PPO violation. I am not taking this under section 771. This is not right. So I'll either let you go back, ma'am, I'm going to let you withdraw your plea, go to trial on it. I'm not taking this under a first offender statute, given the nature of all the rest of these aggravated stalking cases that are going on. So that's my decision. You can discuss it with your lawyer. I'll allow you to withdraw your plea and go to trial. Or you can say, Judge, I understand you're not going to take it under 771.1. I'll invite you to sentence me, or maybe your lawyer can go talk to the prosecutor, but that's what I'm going to do. So I'll put,
For clarity, you're not taking under 771 based on pending ongoing charges.
plus the fact that she had an assault and battery, plus the fact that she had.
Those are convictions.
There's an assault and battery conviction in 24 plus a PPO violation.
Sorry, I don't have the whole list.
That's okay. She had an offense date of September. She had an assault and battery, and she was discharged from probation in December of 25. The conviction occurred in July of 24. She was arraigned on a charge of domestic violence and a PPO violation at the 24th District Court. That offense date was September 20. She still has it. There's been no conviction on that. She's got warrants all over the place on cases, well, I should say pending cases involving domestic violence arising out of a June 8, 26 incident, aggravated stalking from that date, another aggravated stalking from that date, another aggravated stalking from that date. So that's
the primary reason for the court denial is because of the conviction.
the assault and battery conviction and the fact that there's a PPO violation. Okay?
I would like to talk.
You go talk. What do you have there, Mr. McDermott? Which one do you have, counsel?
Iron Fox, Judge.
Pardon me?
Iron Fox Transport.
Is that in? Okay. Real. Iron Fox Transport. 2-5W840465. Okay, your appearance?
I'm McDermott, P46101 on behalf of Iron Fox Transport. Judge, we're amending this to a nuisance civil infraction. I do have full authority on behalf of my client to accept it. Purpose of arraignment, waive formal reading, stand mute.
Okay, so the original charge here is going to be dismissed. That's a no fuel tax decal / permit. And then you're going to have public nuisance under section, it looks like 110-106 of the Woodhaven Code of Ordinances. That's a civil infraction. You're authorized to enter that plea and you're going to enter in that plea, true?
Yes, Judge.
All right, to that charge on behalf of the client, responsible or not responsible?
Responsible.
Please accept the original charge dismissed, $200, and I'm going to give you until July 7th to pay that, okay?
Thanks, Judge. Take care.
Okay, good. Thank you. All right, now, what do I have here? Carter. People against Sherelle Nicole Carter, 26W841163, 26W841067.
Good morning, I'm behalf of TOB 82378 on behalf of Ms. Carter, patient Sherelle Carter.
Okay, so I already arraigned her, and at the conclusion of the arraignment, she told me that she wanted an attorney, so I provided her with your great services. You've got a discovery order. I'm signing the discovery order. You want us to adjourn this, and I'll continue the $300 bonds. What's a new pretrial date, Heather?
We can do July 13th at 1:15.
July 13th at 1:15. July 13th at 1:15. There'll be the new court date. Ma'am, I accommodated you. Can you afford your own lawyer if I didn't appoint you one or not? Where do you work at?
I do work, examiner for hearing aids.
I'm sorry, I didn't hear you.
Examiner, so at DeMont,
How much do you make?
20.
Are you married? The bonds continue, $300 each case. Child to attend school with no unexcused absences. You cannot leave the state, cannot violate disappearance orders. Do you understand all that, ma'am?
Yes.
All right, well, good luck. Thank you. Thank you. Santos, Guillermo Santos III. 3363. Good morning. Your appearance.
Sam Jadala appearing on behalf of Mr. Santos, Your Honor, with the authority to enter into today's plea.
All right, let me just check something here. All right, so this is a commercial vehicle. The plea is going to be to impeding. They're going to dismiss the improper lane use. True?
That is correct, Your Honor.
All right, so you're gonna, all right, to that charge of impeding, responsible or not responsible.
Responsible, Your Honor.
I'll accept the plea 210 and I'll give them till July the 7th to pay that one, okay? 210 by July the 7th. People against Gurmukh Singh, 26.8433364. All right, Mr. Jadali, your appearance again.
Cameron Jadala, P62186 on behalf of Mr. Singh with the authority to enter into today's plea.
All right, so on this one, we're doing the same thing. There's going to be a plea to impeding, and you're authorized to enter that plea, and they're going to dismiss the improper lane use commercial vehicle. True?
That is correct, Your Honor.
All right, on his behalf, responsible or not responsible to impeding traffic?
Responsible.
I'll accept the plea. Dismiss the original charge of improper lane use, 210, paid by July the 7th, July the 7th. Okay?
Thank you.
Have a great day. Thank you.
You and your staff also. Thank you.
All right, what do I have here? Carpenter? People against Carpenter? Davion Jamar Carpenter. 267843414A and B. And I also have 23W831525B. Your name?
Davion Carpenter.
You're charged with driving while suspended from June the 8th and speeding 5 over. There's this, it's 0-point violation. You also have, it looks like some kind of a case in front of Judge Hessen that you never took care of, a failure to pay. You have the right to a lawyer on these. Would you like a lawyer? All right, I'll go ahead and arraign you. On June 8th of 26 at 4:32 p.m., it is alleged that you did operate a motor vehicle northbound on I-75 near King and Woodhaven. Again, with a suspended license, that is a misdemeanor punishable by up to $500 fines, 93 days jail. Costs for all those are 2 points. Do you understand that?
Yes.
Again, you have a 75 and a 70. That's a 0-point civil infraction. It would go on your traffic record, but there's no points associated with that, if you understand that. All right, you also have a charge here. It looks like you didn't show up for a show cause hearing in front of Judge Hessen. And I'm going to arraign you on that. It looks like you owe $423 plus a $35 warrant fee. Is that true, Heather?
No.
Hang on, slow down. Let me
Judge, I'm
ask
sorry.
you.
I missed who you have up there. Was this Carpenter you said?
This is Carpenter, Davion Carpenter.
Okay.
It's 23W831525B.
Okay, let me take a look. His balance, let's see, is 423 on that one.
All right, so I'm going to arraign you for failure to pay 423. I recognize that you posted the bond. Somebody posted it in your name. I'm going to have to go through the whole process. If I find you didn't pay and your failure to pay was not without your fault, the failure to pay 423, you could receive 90 days jail. Do you understand that?
Yeah.
Did you sign, read, and understand the advice of rights?
Yeah.
If you plead guilty, you'd be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes.
You wish to have a lawyer on this case. You waive your right lawyer on this case. I'll enter a not guilty plea for you. We'll have that hearing when you resolve this other case. But if I were you, I'd get her up here because I'm not going to be given time to pay on this. If she doesn't let you post your bond or apply the bond, you've had this going on.
You can apply.
I can't do it by law unless she gives us permission. So Heather,
Can I give how can I go about getting to?
if you want to call her up and tell her to call what's your number again, Heather? Extension
228.
They'll give you instructions down. You go down the hall right now. We'll send these into the prosecutor, and then you can get the process moving with the payment. Okay.
No problem.
All right. And this is Woodhaven, John. So you go down right here. You put this into there. These are done. This one we need nothing. Those are done. You're gonna go down and call. We're gonna talk to my judicial clerk. She'll tell you how to go about getting permission from your, whoever that is, your friend. And then in the meantime, you're gonna go over to the Woodhaven city attorney after you do that, and you'll meet with him and discuss the other case that I just arraigned you on, the drive while unlicensed and the speed. Okay? Jamie Antonia, Williams Bay, 23W831-736. She's not here, is she?
She's on Zoom, Judge.
All right. Ma'am, your name?
Jamie Williams Bay.
You're charged with failure to pay fines and costs. You have the right to a lawyer. If you want one, I'm going to give you one. You want a
yes,
lawyer?
Sir. Yes, sir.
Okay, so we'll give you a lawyer. And Heather, who will be doing this today? It's a probation violation.
Well, Tony Carmen's our house counsel today in place of Crawford.
All right, so we'll give this one to Mr. Carmen. And right now I'm getting at the fence for a couple of minutes. Thank you.
Okay, Judge, so you didn't have a file for Salisa Taliesin up there? Because I asked John to put that up a little bit ago. She's been out on Zoom for a bit.
Lisa Taliesin?
Salisa, yeah, Salisa Taliesin. She was scheduled for 9:45 at arraignment.
This is going back to Carmen? Yeah. That's a new one. She said she gave you a file.
Wilson Taliesin.
Who said that?
Got it. I messaged you to put that up there with the Zelnick file.
That's fine. That's fine. I'm going to take it now. That was, okay. You can bring her in. Salitha Chanel Wilson Taliesin, 26W841-681. And you can bring her in, Heather.
She's trying to join in right now, Judge. It's going slow again.
That's okay. In these Williams Bay, they're going to set you up with the lawyer, okay?
Okay, yes, sir. I don't know why Zoom is taking so long to join people today. There she is.
All right, ma'am, Ms. Wilson Taliesin, start your video and tell me your name, please. Ms. Taliesin, you have to start your video, ma'am. I cannot see you. I cannot hear you. If you now you've muted. I don't want you to mute. I want you to unmute so we can hear you. There you go. Tell me your name, ma'am.
Chanel Wilson Taliesin.
Okay, you're going to have to repeat that again for me. Tell me your name.
Okay. It's Talita Chanel Wilson Taliesin.
Ma'am, are you ill?
No, I'm not.
Why didn't you come to court today? Did we give you permission to appear by Zoom? I mean, you only live down the street practically.
I'm so sorry, but I wasn't aware that I was in person because I couldn't locate my papers. But I knew that I had.
Listen, I'm not getting a good connection, and I don't want to do this by Zoom. I can either have you come up here in the next half an hour, or I'll give you another date, but you're going to have to appear in person, okay?
Okay.
Would you rather that I do it in person today or in a couple weeks?
I'm going to try to see if I can hear you clear. You said, would I rather for you to do it in person or, I'm sorry, sir.
I'm going to reschedule this for you. I'm going to make this easy. Give me a new date, Heather. I'm rescheduling your arraignment and pretrial for.
We can do July 13th at 1:15.
July 13th at 1:15. Defendant must appear in person, okay? Do you understand that?
No problem, July.
You must appear
Yes,
in
sir.
person. Write that down, July 13th at 1:15, okay?
Okay, okay.
You
I have it.
are all
July
set. Thank you very much and best of luck to you.
Okay, thank you.
We'll see you here then. Tabark Jasm Al Baraki, 267-842-950A. And B, you should have been a lawyer.
Yes, I did. I'm not a lawyer, a prosecutor.
What's that?
Yeah, I did get that prosecutor. He did help me out.
No, I know. I'm saying you should have been a lawyer. You did a good job for yourself. You're going to plead to impeding, and they're going to dismiss the driver license expired as well as the speed, right?
Yes, thank you.
Okay, to the charge of impeding traffic, responsible and not responsible. I
Responsible.
don't think you told me your name again when we came back up here. Can you
My name
tell?
is Tabark Jess Alvaraki, Judge.
I'm going to accept the plea. $160 is your total. 160. I'm dismissing the expired license, dismissing the speeding, and you are all set. Just go down the hall and pay that, and you're all set.
Thank you so much.
You too. Have a great day. Thank you.
Which one are we, I'm sorry, which one are we making the impeding?
Sorry, that was on El Baraki, 267-842-950A and B. I took the plea to impeding and I dismissed expired plate. I'm sorry, the expired license and the speeding on motion to the prosecutor. I put the impeding on file A, fines cost 160.
All right,
I'll be
perfect.
back
Thank
in a
you.
few minutes. Everybody stay seated, please.
So, over 7.
Four, 3, 455A and B. With the plug. Yeah, I just can't. Your name?
Josh Berryhill.
You're the president of the corporation?
Yes. Managing author. LLC, yes.
I can't let you appear on this. It's not my rule. But on misdemeanors, I just can't let you appear on this. You're going to have to get a lawyer. We're going to have to adjourn the arraignment and pretrial. It's not my rule, okay?
Is there a possibility for me to talk to the prosecutor?
I can't let you do that. I mean, it's you can't represent a corporation. You're not a licensed lawyer. So I have to insist that you get a lawyer. It's not my rule. Give me a new date, Heather.
My apologies. When I did go speak to the officer that issued the ticket, and he gave me he told me that I don't need a lawyer.
He's not the judge. That's what
I understand. I'm just explaining why.
That's fine.
I didn't.
That's fine. Heather, give me another date, please. Maybe he's not there.
Oh, I'm sorry, Judge, I was muted. Monday,
That's
July
okay.
13th at 1:15.
So July 13th at 1:15, okay? And I will let your lawyer Zoom. What's your first name again?
Jeff.
Jeff what?
Berryhill, BERRYHILL.
And you're the managing owner?
Yes, sir.
I don't mind if your lawyer zooms in, if that'll help you keep the costs down. I don't mind if they do that. Okay?
Okay.
So
do I just show the revised summons to my lawyer and indicate?
You tell them the judge is insisting that you bring a lawyer on this because you're charged with the company's charged with a misdemeanor. You're not licensed to practice law. And that's just the way it is.
I see. Okay.
All right. Good luck. Destiny Danielle Henry. Wait 1 second, ma'am. Let me get your lawyer in here. We're gonna need a pre-trial date on this other.
Okay, Judge.
All right, you can come on up here. Destiny Danielle Henry, 267-842-495. Okay, ma'am, come on up here. Tell me your name. Mr. Carmen.
Michael Carmen, P7384, on behalf of the defendant, Your Honor.
So I think my next date is July 13 at 1. Is that right, Heather?
We can do that or the 22nd, yes.
Yeah, let's do July 13th at 1.
That's the exact date of for proceedings. Can we use the next date?
What time is that? Well, you should be able to be here at 1, right? Okay, so July 13th at 1. We'll see you here then. Good luck.
Thank you.
Well, I'm gonna get your notice. Guzman. First, Kristen Fern Guzman. 267-841-847.
Michael Carmen, P7384, on behalf of the defendant, Your Honor.
Ma'am, your name?
Excuse me, Kristen Guzman.
All right, so this is gonna be a plea to stalk, not taken under 771.1, correct?
Correct, Your Honor.
Wait, how did all this end up in this blue folder here? All right. Give me a second, jeez. Ma'am, you already took your plea to stalk.
What up, Carl?
Back by 9:30.
So
Did you
okay, hang on a second. I got the file and I just want to make sure I got everything in the right place. For some reason, I got put in that blue folder. So rather than take a plea to stalking again, I just need an understanding from her that she understands I'm not going to take it under section 771. Do you understand that?
Yes.
So you understand this conviction will remain on your record? And you understand I would have allowed you to withdraw your plea and proceed to trial since I told you I wouldn't take it under that statute?
Yes.
And notwithstanding that, you still wish to plead to stalking, knowing it won't be taken under section 771.1. Is that correct?
Yes.
All right, so I don't see any need to take the plea unless you do again.
Your Honor, just for clarity, I did go back. I talked with the prosecutor. He was not willing to offer any, I guess, amended charge. What he did write was that he didn't have any objection to any incarceration in this matter. So I think she's still getting, some benefit of it being pre-trial.
Sure. Do I have the victim here by chance? I want to make sure I saw the victim's letter, and I want to make sure that she's not here. Michelle Fonseca, is she here by chance? Has she been here on Zoom at all, Heather?
No, Judge.
Did you read this victim's rights letter? Did you get a chance to review it with your client?
Yes, Your Honor. I read it and I gave it to her to read.
All right. I just wanted to be sure that, and if you had a chance to review the report with her, the pre-sentence, and are there any material additions, corrections, or deletions?
Your Honor, one material addition, my client is also working at Sally's Beauty Supply part-time, usually just twice a month, insurance $14 an hour there. Otherwise, everything seems to be accurate. Would ask for adopt the recommendations. But I guess since, you know, she can't use the 771, I would ask that the court consider shortening the probation to 6 months, please.
I have real concerns about you, Ms. Guzman. Would you like to tell me anything? I can't hear you.
You know, Your
I'm gonna, and I don't want you to talk about any of the other charges that you have pending. But you got a lot going on here, young lady.
Sure, I'm trying to get everything straight out.
Well, one of the things you can do is stop harassing and stalking people.
I'm taking a break from social media. I deleted that app. And I just been concentrating on working two jobs. Staying out of trouble.
Well, I sure hope so. Now, under local ordinance, this stalking charge is just a 90-day misdemeanor. But I'm just telling you, I have real concerns here about what you're doing.
Right.
18 months probation. You cannot leave the state without consent of the court or violate any law or ordinance. You must report to probation as direct. You're to attend a psychological evaluation and treatment if recommended. You're not to have any contact with Michelle Fonseca. You're not to possess firearms. You're not to possess dangerous weapons. You're to serve 7 days or 56 hours of community service. I'm going to give you until August 15th to complete that. No contact. We understand that.
I understand.
100 fines, 200 costs. 75 if enjoyed $50 justice assessment. That is 4 1/4. Screening fee is 60 for 485. Probation fees are 360. Bring your total to 845. You may be eligible for early discharge if you're compliant. So after 9 months, if you're compliant, you can come in here, and by statute, you would be entitled to early discharge. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal if you cannot afford one. I'm going to let you, do you have any money to pay today?
I can make that.
How much?
I could put $100.
And then how much could you pay weekly, you think?
I get paid every 2 weeks. So
When do you get paid next?
26.
All right. How much can you pay bi-weekly? I'll only have you do 60. Pay 100 today, 60 bi-weekly beginning June the 29th. Now, if you ever need more time, no problem. Come talk to me before the due date, or you can call the court. We'll go on Zoom. I'll give you an extension. We will meet with probation. So go down to $100. Go over probation, no instruction. Any questions?
Just for the cashier to pay the 100.
Correct. Good luck. Thanks. Purcell. People against Deanna Lynn Purcell. Accused 5W8398. I'm sorry, 83968. A and B. Ms. Purcell, you're.
Deanna Lynn Purcell.
Michael A. Carmen, 373 on behalf of the County Government.
All right. So we got attempt possession of a controlled substance she's going to plead to, right?
Yes.
That's on count 1, file A. And so the original charge will be dismissed on that. And then she's going to plead to impeding traffic, and they're going to dismiss the suspend and the possession of a controlled substance. True?
Yes, sir.
Is that what you want to do?
Yes, sir.
If you plead the impeding traffic, that's 0 points. It won't go on your record. And if you plead to attempt possession of a controlled substance, that is punishable by up to 250 fines, 45 days jail, costs, or all those. Do you understand that?
Yes, sir.
Did you sign an advice of rights and read it and understand it today?
Yes.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes, Your Honor.
All right. To the charge, attempt possession of a controlled substance, how do you plead?
Guilty.
Were you on Allen near West in Woodhaven, August 23 of 25 at 2:03 in the morning?
Yeah.
And did you have, well, let me ask you this again. To the charge, attempted possession of a controlled substance, how do you plead?
Guilty.
To the charge of impeding traffic, responsible or not responsible?
Stop.
Were you in the city of Woodhaven, County of Wayne on Allen near Weston, Woodhaven, August 23 of 25 at 2:03 in the morning? Were you in possession of methamphetamines?
Yes.
Are you on probation or parole? Anybody force you to plead guilty?
No.
Plea is accepted to attempt possession of a controlled substance. I'm dismissing the original charge, possession of a controlled substance. I'm accepting the plea to impeding traffic. I'm dismissing the suspend. I'm going to order a screening and assessment here. Are you still fooling around with this stuff?
No, God.
You're not?
No.
So if I send you for a drug test right now, you would pass it.
Yeah.
Don't lie to me. Would you pass it?
Yes, Your Honor.
What is she doing for herself? Where does she work?
I work at Pete's Place in Taylor. I'm polygraph from the waitress.
All right, you're staying out of trouble?
Yes, sir.
Why didn't you show up on this case a long time ago?
I had another court date on the same day within a half hour of each other.
So you thought you'd just blow this off?
No, the one was Zoom and it was arranged. I was hoping I'd be able to do the Zoom and come here after. They ended up just,
You live on Marion Drive, right?
yes,
How far is Marion Drive from here?
just a couple minutes.
I know.
They ended up arraigning me that day.
What's that?
They ended up sentencing me that day on Zoom. They took care of everything that day. It was just supposed to be an arraignment. They ended up taking care of everything that day. Alan Park.
All right, we're gonna set a sentencing date. What do you have for me, Heather?
We could do, you want to do the 22nd on this one, Judge?
I'll do whatever you want. You're the
Let's
boss.
do the 22nd at 8:45.
At 8:45. Okay?
Okay.
You're staying out of trouble.
Yeah.
All right. Where'd you go to high school at?
Why not?
All right. Stay out of trouble. Meth's bad. We don't want you going down the road of meth. You follow me?
Yes, Your Honor.
All right. Go down the hall, get your notice, and then we'll see you back. You're all right? I wish you well. I really did.
Thank you.
Good luck. Carpenter, Davion Jamar Carpenter. 2-6-W-843-414-A-B. And wait a minute, let me just double check here. I got the 414A. I got 414B. And I also got 23-W-831-525B. Your name? So they're going to let you apply the bond. And it was 4,500, 10%. Right, Heather?
I believe that's what it was, Judge. If it's there.
These new rules. I'll tell you what, I'm gonna apply the bond. We're gonna return $35. And your girlfriend, is that your girlfriend?
Yes.
She called and gave us permission to apply the bond on her.
Yes.
True, Heather?
Yes, Judge.
So return $35 to poster. Apply 415. Balance waived. Case closed. Okay, so that's what we'll do on the first one. Are you with me?
Yes, sir.
All right, now on the other case, what'd you work out with the prosecutor? You're gonna plead no license on person on both. What you mean on both files? It's only got one. Do you know what he means by that? He's gonna be pleaded to 2 misdemeanors?
Yeah, he's that he would dismiss it, but he said, if you have any questions to let us know.
Yeah, call him in here, 249. Let's start out like this. If you plead guilty to no ops, that's a misdemeanor punishable by a felon's term. He's got these two.
Oh,
Up to 100 fines, 90 days jail, costs are all those. Do you understand that?
yes.
I don't know what he means. It doesn't make any sense to have you plead to no ops if you got a speeding. Maybe he'll give you impeding. I don't know, but I'll ask. You don't want to do impeding?
He didn't say anything about it.
Doesn't make any sense to me. Why would you plead to a misdemeanor if you got a civil infraction? You can do impeding. I'll talk. Did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes.
Mr. Urick, your name?
Of the city, what name?
Forgive me, but I'm having a hard time understanding. Why are you having him plead the two misdemeanors? Who's got to suspend and speeding?
There are two separate files. There's a 23 file and
Yes, 23, he was already sentenced on
I wasn't aware.
by Judge Hess.
The RJ card seemed to,
That's all right. We're just applying the bond. Do you want to give him impeding on this?
impeding on the speed and a no lapse on the new DWS, Judge. I apologize.
That's all right. If you could just write that up. So it's going to work out better for you. If you plead to impeding and you plead to no one, I'm going to dismiss the suspend and the speed. Do you understand that?
Yes.
So that's better. Impeding is 0 points. It won't go on your record. Do you understand that?
Yes.
And you understand all your rights?
Yeah.
And you understand you plead guilty, you'll be giving up all those rights?
Yeah.
You do have the right to a lawyer. Would you like one? You waive the right to a lawyer? You charge no valid operator's license on person. How do you plead?
Yep.
Were you operating a motor vehicle on 75, I-75 near King and Woodhaven, June 8 of 26 at 4:32 p.m.?
Yeah.
Did you have a valid license in person?
No.
Are you on probation or parole?
No.
Anybody in the world force you to plead guilty?
No.
And again, to the charge of impeding traffic, responsible or not responsible?
It's fine.
I'll accept that plea, accept the plea to no ops, dismiss the suspend charge, that's a misdemeanor, dismiss the speed charge, which would not be on, it'd be on your traffic record, and it would have been 0 points, but still, you don't want that on the record. Okay. So. Okay, so, but he's still pleading to impeding, right?
That's correct, Your
I
Honor.
don't see where you got that on here.
Should be under item number 2. Impeding.
You got limited access and speeding being dismissed. I don't see where you wrote impeding. So it just changed that. So you understand that's what's going on here, right?
Yeah.
All right, so I'm accepting your plea to no ops, dismissing the suspend, dismissing the speeding, accepting your plea to impeding, and I'm ready for sentence. Are you?
Yes.
What do you do for a living? Why do you think? Why are you driving around without insurance? I mean, without a valid license? You still don't have a valid license. How come you're doing it?
I think you tell that.
You drive a high-low for who?
Universal Ramos,
How much you make there?
$20 an hour.
Kids?
Yep, I have one.
You gotta use your head. You don't want to be giving courts your money, do you?
No.
Gotta go get this taken care of. I'm not gonna make a big issue, but. Stop it.
I'm on.
Good enough. On the impeding, I'm gonna simply fine you $165. On the other charge, 100 fines, that's on the no op, 75 victims' rights, $50 justice assessment, 100 fines and costs, 3 1/4 or 60 days. So you owe $490. Do you have all that?
Today.
How much you have today?
Can I check to see what time we need?
It's 11:05.
I get paid today, but I won't get paid until after 3 o'clock.
Okay, when can you pay these? Can you pay the impeding tomorrow?
Yeah, but I can.
Pardon?
I can.
So that's by June 25th, you pay the impeding. That'll leave you with, and that's $165. Then you have $325 you owe on the no ops. When can you pay that?
In 2 weeks.
July 20th? I'll give you all the way to July 20th. You gonna be able to pay by then?
Yep.
So you think that's cool? Is that what you said? It's cool?
That's fine. That's fine with me.
Okay. July 20th. Now listen, if July 20th, we always get expenses, right? Something happens, call the court, call them. And you can either come in here on or before that due date at 8:30, you can call the court. We'll go on Zoom and I'll give you an extension. Just don't ignore me or else I'm not gonna be nice. Fair?
Fair. So just for the record, 165 tomorrow
Correct.
and 325 by July 20th.
Correct. You're all set. Have a good day. Good luck. You're a nice kid. Stay out of here. Brandon Allen Trumbo, 267-843-216. Come on up here, Mr. Trumbo, and B. All right, your name? You're gonna plead impeding, you're gonna dismiss the suspend and speeding, right? Is that what you want to do?
Right.
To the charge of impeding traffic, which I'm putting on file, I guess, Heather. Responsible or not responsible?
Responsible.
How's your record?
Decent.
That means it's,
There's things that.
I'll accept the plea to impeding, dismiss the suspend, dismiss the speed. Let me see what your record's like real quick. How old are you?
18.
You graduate?
Not yet, Your Honor.
Where are you going?
Like a trade school, so it's,
You didn't graduate high school yet?
no.
You gotta make sure you graduate, right?
Yes.
175 is your total. Can you pay that now?
So I that next Friday.
Yep. June well, next Friday is July 3rd. We're not open. I'm gonna give you July 6th, okay? I do wish you well. Good luck to you. Have a great day.
Thank you.
You're a nice kid. Act like it. Thanks. Williams Bay. Jamie Anthony Williams Bay. 23W831-736. Ma'am, your name?
Jamie Williams, Bay.
Counsel?
Michael A. Garland, P73824, the head of the Your Honor.
I don't know what to do with her. She owes all this money. She's owed all this money. What am I supposed to do with her? Does she have, please tell me she has the money so I don't have to send her to jail.
Well, my client paid a $200 bond. He can pay $400 today and then the balance in a week. Jane, is that accurate? Jamie?
Yes.
Hear what I just said?
I'm sorry?
Did you hear what he just said? He said you could pay $400 today. You posted a $200 bond and that you could pay the rest in a week. Is that what you said?
Yes, that's what I said.
And Janie, is that accurate?
Yes, that's what I said.
Okay.
Did I ever revoke her HIDA status, Heather?
Let me take a look here, Judge.
April 21, I said.
I don't see that we did. Because it's still a non-public status in our system.
Who's your probation officer again? Let's call in.
It is Miss Wilds.
Let's call in Beth, please. So I want to read my notes. On April 21, I took her plea. I set a sentencing date for May 27th, said she was to attend the Positive Strategies program. She was going to bring proof to defense attorney. DJ something program at Oakland Community. She used to take care of at least a couple. Well, I just can't even read my own writing. It got a little ugly there. Is Beth coming?
She's on her way here.
So I took your plea on April 21. Did she do the Positive Strategies program?
I believe that's scheduled for Jane. You said July
9th. Yep. 6 p.m.
And then what else did I say? Bring proof, defendant, attorney.
Criminal justice transcript for my school.
Did you bring proof of that to Ms. Wilds?
Yes, I sent it to Ms. Wilds. Yes, sir.
And then it said defendants take care of at least a couple other warrants. Did you do that?
Not that I'm knowing of, because I didn't even know I had anyone.
Classification mark.
How's she doing on this?
I'm gonna say not well, Judge. The last time we were in court, you did order her to complete the economic crime program. You ordered her to provide proof of schooling, which she did email to me, an unofficial transcript. I think last time she said she was going to school for criminal justice, but it appears legitimate, but I can't decipher what school it's from.
Oakland Community College.
And I ordered her to clear some of her warrants off. I think at the time she had to post a bond, and again, to discuss the money at today's hearing as well. So those were the items that you addressed. At the very, very last hearing, I believe you adjourned it to today because of the lateness in the day, if I'm correct.
You are not very responsive. You know that? Yeah.
I'm trying to get everything together now. Like this was all down the line when I didn't know anything. So I'm trying to get everything together now.
I mean, I won't forget this case. This is the one with the lottery tickets, and you and your lawyer were trying to blame the manager for encouraging you to take the lottery tickets. I mean, I remember going through that. That was ridiculous. Like, I mean, it was beyond ridiculous. And then you just kind of went AWOL on us. We didn't see you from October of 23 until April of 26. You did send a letter in June of 24 saying you wanted to appear by Zoom. And I said, no, you had to appear in person. Now, I don't know what to tell you, Ms. Williams-Bay, but you are only 23 years old. True?
Yes, sir.
It's time to start acting like it.
Yes, sir. Honestly, I'm literally working 3 jobs now because my Amazon job not posting shifts. Because I'm working flex, but I got two other jobs, picked up 2 other jobs, and I've already started them. And I'm definitely dedicated to getting this out the way because I should have been got this out the way. And this is just catching up to me because I should have been got this out the way.
I can't revoke your height status at this point. When's the program? What'd you say the program was? What day? Positive strategies. When you go into that?
July 9th. I'm already in. I'm already scheduled.
Sorry.
Is Mr. Carmen, is it going to be easier for you to take the 13th or the 22nd?
Yeah, they don't have a phone on me. It's in the other room. I haven't looked.
I think Heather may know. Heather, do you know when Mr. Carmen's here again?
Let me take a look at the calendar here. So we're looking between the 2 dates that we have coming up in July. He's not here on the 13th. Let me look at the 22nd. He's not here on either one of those dates.
Well, let's adjourn it to July.
Yeah, we're actually still looking for an attorney for the 13th date. We don't have one yet.
We're going to adjourn this to July 22nd at 8. Is it 8:30? Is that good?
Yes, that's good, Judge.
I expect everything to be done.
Yes, sir.
I expect everything to be paid.
Yes, sir.
Okay? And then I can figure out a way to, geez, you got to be more. That's all I'm going to say. Have a good day. Kenneth Mandel, thank you both. Merck McCurdy III, 26W84304, 7A and B. Good morning, Mr. Camilleri.
Good morning, Judge Attorney Jack Camilleri, on behalf of Kenneth Mandel, McCurdy III, Clinton and Court.
Sir, your name? All right, so we have a charge of operating while intoxicated, and we also have a charge of minor in possession. As I understand it, first of all, he's going to stand mute and waive formal reading. Is that true?
Correct, Judge.
And then they're going to dismiss the MIP. They're going to dismiss the OWI. He's going to plead to impaired driving, and then they'll move to dismiss the 2 counts, correct?
Correct.
Is that what you want to do, Mr. McCarty? You plead guilty to operating while impaired. Here are the possible penalties: up to 300 fines, 93 days jail, 360 hours community service. Court costs are all of those 4 points. License suspension or revocation in accordance with your record. Your vehicle could be or might have to be immobilized depending upon your record. Do you understand that? That's right. And did you sign, read, and understand the advice of rights?
Did you read and understand?
Yeah.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Sure.
All right. To the charge operating while impaired, how do you plead?
Guilty.
Were you operating a motor vehicle on May 24, 26 on Western Hall in Woodhaven? We got to keep it going.
Oh, yes, Your Honor.
Was that at 6:57 in the morning?
I believe so.
Did you drink alcohol prior to operating that vehicle that day?
Yes, Your Honor.
What did you drink and how much?
Like 5 beers, 6 beers.
What time did you stop drinking the 6 beers?
Late in the morning?
Yeah.
Was it early morning?
Yeah, it was early morning.
Like early morning, you mean 2 in the morning?
Yeah, somewhere around like 2, 3.
And you were operating this vehicle, and where were you going?
To the store, I believe.
Why were you pulled over by the police?
Speeding.
You think you were speeding at least in part because of your alcohol consumption?
Yes, Your Honor.
And counsel, were the results of the breathalyzer 0.149? Did you stipulate that that was an accurate reading for purposes of the plea?
Stipulated,
And was that a breathalyzer or toxalyzer?
yes.
And how old were you at this time? You only 18?
Yes, Your Honor.
And are you on probation or parole?
Not right now.
Anybody force you to plead guilty?
No, Your Honor.
Please accept it to operating while impaired. The OWI and the MIP are dismissed. I'm going to refer you for a screening assessment. We have to address bond. Who's this with you?
Mother,
This is not good. You can't be doing this at 18. This is bad. I'm serious as a heart attack when I tell you that. I'm not overreacting either. When I see people come in with drunk drivings at that level, when they're 18, they really do typically come back with another one because they have a serious drinking problem. I'm not trying to make you feel bad. I'm just telling you the way it is. I'll give them a personal bond of $1,000. My court officer is going to hand you a form.
Your Honor, there was a pending charge.
He's got another charge pending?
As an officer of the court.
For what?
OWI.
In front of me?
No,
From Judge Hessen?
yes. I'm not gonna try to say that my client was given lottery tickets. I was here before what you just said about the other one. I've been in front of you way too many times. And I feel compelled that I gotta tell you there's a pending charge.
Well, I appreciate your honesty. That's what I expect lawyers to do. And I appreciate it.
I just
Some
looked
do,
it up.
some-
He goes in front of Judge Hessen tomorrow on that one, it looks like.
Has he gone in front of her for arraignment yet?
No,
No, he has not.
So this is not good. You know, did you graduate? From where?
Clarkson
What is your plan for the fall?
Community College in Florida for a year.
You might want to save your money. You keep getting in trouble like this. I don't care if you go to Harvard and are the valedictorian. Nobody's going to want to hire you. Now, I don't want you to say another case about that, another word about that case. You're representing them on that too?
yes.
Good.
Give them my Oscar winning.
Listen, here's what you're doing. I'm telling you, I'm not impressed. AANA 3 times a week. You're going in person, no alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. I want you to understand also, you will be on a SilverLink device by the end of the day. Probation's going to explain that to you, how you would go about acquiring that. You're going to have to blow into that machine 5 times a day. Your party days are over. You got it?
Yes, sir.
Good. I mean, I don't want to say too much because I don't want you to say anything to incriminate yourself, but my Lord, after you had this one, I'd have thought you'd be pushing the car before you'd even be driving the car, even if you hadn't consumed any alcohol. And now I find out that you got another case pending. Bad, really bad. You better get your act together now, son. Is father, are you still married to his father?
Father's passed away, Judge, when he was 15. He had a pulmonary embolism.
Yes.
I'm sorry. And you're raising this, is this your only child?
No, I have 3. He's my oldest. I have 3 younger ones.
You gonna be a good example or a bad example?
They actually work together, Judge. Mom was referred to me by a corporate client. Kenny here works at the same corporate client, so they work together. I have said so much to Kenny in my office, Judge. I don't know if I'm annoying to them, but I tell them about reality. I tell them about generations before him, how they had so much on their shoulders and they were responsible. I talked to them about Judge Kirsten in his World War II. You know, all those guys were 20, 22, and look what they went through. Look what they did. And they weren't belly aching about too much responsibility. And I've been to Omaha Beach. I've been to Normandy. And these guys have got to realize that, first of all, they can do 3 times more than they know they can do.
Right.
Second of all, they got to realize that we're giving them a pass in today's standards versus what things were like 60, 70 years ago for them.
No doubt.
And bad things happen to good people. If you think that it won't happen to me, BS.
Right.
Okay? BS. Shit happens. And you can wrap people around the telephone pole. You can wrap yourself around the telephone pole.
Exactly.
You know, I can go on.
I'm glad you're talking to
He's a
him.
good guy. I can tell he just needs to be woken up, put on the right path.
Right.
Mom's been in my office. I give her a lot of credit.
I'm glad you're talking to him.
Oh, gosh, I go on and on.
I know, I'm sure. Did I give you a sentence date?
You did not give us.
What's a sentence date, Heather?
The 22nd at 8:30.
July 22nd at 8:30, good with you?
Yes, sir.
And you're gonna go meet with probation, you're gonna fill out a questionnaire. You write that in my register, will you please, Heather? I kind of just put
Yes,
it
Judge.
on. And you're gonna go get that sober lake today, you got it?
I'll explain to you.
Okay, thanks a lot. We'll
Yeah.
see you here then. Get your life together. Good luck, thanks.
He
Thanks.
can recover. He just has to
Right, walk the
put him in
ground.
the right track.
Exactly. Thank you.
Judge, did we dismiss the MIP on that one?
Dismissing the MIP and the OWI on that.
Okay, perfect. Thank you.
Thank you.
If you so has one.
All right, thanks, Judge.
Thanks a lot.
Yep. You're welcome.
Yeah.
Allegations. I spoke to Agent Mormon, why he would be blowing numbers and then having these negative ETs. He says he doesn't know why either, just that obviously something's happening before he's blowing. But
something's happening before he's blowing or before he takes the ETG?
he said before I asked, why do you think he's blowing numbers when the ETG is coming back negative? He said he's coming in contact with something with alcohol prior to blowing. The ETG is more sensitive. So I've never seen a situation like this. Typically the ETGs, come back as positive. And I told Mr. Holdaway, I've never had a situation like this.
When you have low numbers, which these are low numbers on an ETG, what I find interesting, just so that you know where the court's head is at, is had he taken the test the next day, we might have different results.
Can I speak? Sir, good afternoon. I have one kidney and it takes my body times to siphon through alcohol, if you will. And I don't know how the tests work. I don't technically one or the other, but just I put that out there. If I were to blow anything, I'm pretty sure it should show up on a P test.
Not if he waits a day, really 2 days. And then if he is all is flushing his system, it may not show up.
Okay.
But it seems rather strange because on the 11th, well, let's just go back. January 11th, 2026, he's blowing numbers of 0.02, 0.025, 0.19. They contacted him on the 12th, asked if he consumed alcohol, and they requested an ETG test. And I think the date is important. He reported then on the 13th and submitted to an ETG, which is negative. That 2 days. He then in February 8th, he blows 022, 021, 018. He denied consuming alcohol again on the 8th, but he reports in to take his ETG test. They requested an ETG test. He reports on the 10th. That also then comes back negative. He's then missing some tests in March, and then in April, he blows on April 14th. He blows a 026, 023, 021, 018, and then comes down to a 0 at 11 a.m. They request an ETG test. He reported on the 15th for an ETG test, but was unable to give a sample. He then came in, and again, we're at that 2-day mark, and they didn't do an ETG test. They ran the wrong test on him on that day. Then May, he then again gets alcohol positive test of a 0.05, 0.028, 0.027, 0.023, 0.015. That was on the 25th. They call him on the 26th for an ETG test. He doesn't report to the 27th. That one comes back negative. From my standpoint, I know exactly what he's doing. In terms of the testing.
Yeah, I think obviously we don't know what would happen if he had reported the next day, since he didn't.
Yeah, you're right. He did on one occasion, but then miraculously was unable to give a sample.
I tried. I'm sorry. And the guy who was working there, it was 4:45, and I said, I can finally go, because I drank 15 cups of water sitting there, and he had already left for the day. So I had to come back the next morning. The next morning, they were out of power when I was there at 9 a.m. So I had to wait until 1 o'clock in the afternoon. It was when we had the tornado that touched down in Ann Arbor, and it was that day. And so I ended up taking it at like noon or something like that when they finally opened it up. But Your Honor, I haven't drank. I had my 18-month anniversary on the 1st. And I'm very proud of that. And I mean, those numbers would say that I had a beer or two. That's not in my nature. If there's one, there's going to be 15. So, I'm sorry. I don't know why that's blown. Since I was sitting on the bench there, and I mentioned I had one kidney, I have to get blood taken quite often. And the only thing I'm starting to think of is that, I know sometimes when they take an excessive amount, they put something else back in, fluids. If that has something to do with it, I doubt it. I never thought about it before, but I haven't drank. I mean,
say the sober league is a breakfast. So it's not like.
Right.
The only thing I have to add, Your Honor, is, Mr. Holdaway is appearing at community corrections when he's told to. I think that demonstrates some kind of willingness to be a participant, active participant in the case. He's been blowing for when it doesn't, since July of last year.
For 1,000 of them.
He's been communicating with Agent Mormon. He comes in when Mr. Mormon tells him to come in. Like I said, I think that does demonstrate from running from this. And I will just add also, Mr. Holdway was housed in the last couple of weeks after living at the Delana Center for about a year. So things are stabilizing for him, which I think is good.
What I'm going to do in this case is I'm going to continue to defend its probation in this case. He is to pay that $852 arrearage as arranged at $142 per month. I'll do that, but he's going to have to arrange to start those payments. He is to report to probation. Ms. Calera, do you have a July 6th time that he could report?
Your Honor, that's not a good date, right? Have the.
Okay, no, that's fine. Any 7? What time? Will 11 a.m. work? All right.
And that would be me.
I will indicate that the defendant is to report to probation July 7th, 2026 at 11 a.m. in person. Then he's to report as directed. He's to become compliant with all other previous orders and terms of the court within 30 days from the time of his appearance. I am going to remand the defendant based upon the violations to date at this point. Served 10 days in the Washtenaw County Jail. When defendant is released, he's to be released, but only after a scram tether is placed. Thank you. Courthouse case, People versus Diane Baumgartner.
This is about defendant Nicholas Bukovich on behalf of Ms. Baumgartner, who's now approaching.
I ain't know where to come in.
No, you're perfect.
Your name?
Diane Baumgartner.
Okay.
Teresa Claire on behalf of probation. Ms. Baumgartner is scheduled before the court for a violation of probation hearing. Ms. Baumgartner had drugs to the in this case back in January of 2024. At that time, the court issued a bench warrant. She was out on bench warrant status for a long period of time until bond was posted on May 20th. And then at that time, the court did set this for a violation hearing. Ms. Baumgartner was in contact with my office after the bond was posted, and I had a communication with her. She indicated that she kind of just stopped doing things because she had several serious health issues. She had a couple of heart attacks. She also had appendicitis. So she was recovering. I do know, Your Honor, that the bond was posted in the amount of 500. There's $450 available. Ms. Baumgartner has completed programming and only owes a balance of $449 in this case. Given all circumstances, probation at this time would like to dismiss the violation here and have the court apply the bond to the outstanding balance and also dismiss the case pursuant to the prosecutor's discharge on probation.
Maybe asking that the court file the recommendation of probation in this matter.
Would?
Yes, I would.
You don't want me to lock her up?
No, I prefer you not.
Oh. Why do you look that way, Miss Baumgartner? You don't want me to?
No.
No. Okay, that's okay. I'm not.
Okay.
Okay. All right. What I will do is I'll apply the bond to the outstanding balance in this case. I'll dismiss this case pursuant to the prosecutor's deferred. I'll discharge you from probation with improvement and wish you all the best, okay?
Thank you very much. Thank you.
You take it.
Thank you, you too. Thank you.
Court calls case People versus Jaden Patrick.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Patrick.
Tracy Claire on behalf of probation, Your Honor, Mr. Patrick was scheduled before the court for a violation of probation hearing, given that he's non-compliant with the terms ordered by this court and that he is not present. Probation is requesting a bench warrant.
The bench warrant will issue for defendant's failure to appear. Bond is set in amount of $10,000, 10%. Court calls case People versus Brian Culver.
Assistant Public Defender Nick Bukovich on behalf of Mr. Culver, who is appearing via Zoom.
Sir, please state your name.
Brian Culver.
All right.
At this time, Your Honor, we have reviewed the pre-sentence investigation report. We have no additions, deletions, or corrections. We would ask that the court adopt the recommendation of probation.
Mr. Culver, anything you want to say before I impose sentence?
No, sir.
Sent to the court, I'm going to place you on 4 months prosecutor deferred sentence. You're to pay $480 fines and court costs, $120 probation oversight fees, $25.61 restitution to Walmart payable through the court. When can you get that paid, sir?
The full amount?
Yes.
Oh, okay. I didn't know if you were just referring to the restitution because I had talked to probation about that. I'm a little bit of a financial trouble, so I was trying to use the full time of the probation to get that paid out.
Payment plan is arranged by probation. When are you going to pay the restitution?
Like I said, I think I have to pay it by cash or money order. Is that correct, sir?
That's correct.
So, yeah, just as long as I know where to send the money order, I can do that today.
Okay, the money order can come to the court. Make sure that you reference your court case number.
Okay.
And then probation, and then a payment plan as arranged by probation for the rest. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to attend individual therapy with verification to probation. There's no going to any Walmart store in the state of Michigan. I'll set a review hearing October 28th, 2026 at 12 noon. I'll order 93 days in jail that is suspended. Okay.
Okay.
Thank you.
Thank you.
Court calls case People versus Cassandra Ormiston.
Tracy Claire on behalf of probation, Your Honor, Ms. Ormiston was scheduled before the court for a review hearing on a prosecutor deferred. She did complete all terms ordered by the court, and I did wait for the hearing. Probation's recommended and discharge her from probation.
Hearing no objection, so ordered. Court calls the case People versus Shante Wingard.
Tracy Claire on behalf of probation, Your Honor, Ms. Wingard was scheduled before the court for a review hearing on a prosecutor deferred. She did complete all terms ordered by the court, and I did wait for appearance. Probation's recommending that the court dismiss the case pursuant to the prosecutor deferred and discharge her from probation with improvement.
Hearing no objection, so ordered. Court does call the case People versus Leslie Brown.
That's me, this is the public for the morning hearing with Mr. Brown. Mr. Brown, here, Robert, please.
Leslie Brown.
Now, we're here for a show cause. Mr. Brown indicated to me that he would be able to pay about half today. I'm not sure if that payment was made already or not. He also wanted the court to know the sentence on the 30th to 1 year in our jail. So he will be here for the next 12 months.
Out of what court?
Circuit court, right, Mr. Brown?
Yes, sir.
All right, so how much can he pay today?
They hit my account, my child support. I can pay 100 today.
Yeah, you used to pay $100 today, then I'll refer the balance to our collections department. So get that $100 in, please.
Okay.
Okay, that's the way we'll. All right, thank you.
Thank you.
Courthouse case, People versus Kyle Jackson.
Show cause for action.
Kyle Jackson. About 1270.
Yes.
Bench warrant will issue for defendant's failure to appear, bond set in the amount of $15,000, 10%. The warrant will issue immediately. Court calls the case People versus Sandra Sanchez.
Assistant Public Defender Nick Bukovich on behalf of Ms. Sanchez, who should be appearing via Zoom.
Ms. Sanchez? This is show cause.
Yes, I'm here.
All right. State your name, please.
Sandra Sanchez.
All right. Show cause CO 726.
Yes, Your Honor. I was speaking to my client. I know she was on a payment plan. However, due to an unexpected garnishment of her wage garnishment, she lost the income she intended to use to pay for these costs and fines. She did make a $40 payment today. She does believe she can make it $50 payments per month to resolve this matter.
50 per month?
Yes.
You paid 40 today, is that right, ma'am?
Yes.
All right, what I'm gonna do is $50 per month